Petition lodged. Petition item number. And it engages from. Yes. My petition lodged. I beg to mention item number 21 lodged. And 21, 21 lodged. Lanet engages council is on deep lodged. And the action for the lodged. Motion.
Well, I think 13 to 20 are analogous matters, well, pertains to eviction of from forest land. When the matter.
Okay, but you mentioned for listing of an IV. Or motion. IA. Listing. Listing. IA for what? It is a prayer lordship, like a writ petition. In August 2025, we were given an order of maintaining a status quo, whereas the respondent authority, they haven't maintained it. So in that regard, we're filing an IA, but hasn't been listed yet. Any day, if before people, it could be possible.
I'd like to mention for listing motion, for the distribution. It is a matter regarding the property dispute between the legal heirs.
Property dispute between.
Between a legal heirs lordship. Legal heirs lordship. It is a matter of the petrol pump which is held by our predecessors of the deceased person lordship. But the matter has been without the consent of the petitioner lordship, the siblings of the petitioner have filed the WPC lordship. The history of this case lordship. In division bench, the honorable before lordship. The urgency of the matter is no lordship, it's the order column.
Lordship, I beg to mention for listing of a writ petition, your lordship, it is pertains to land matter, your lordship. Eviction from land. The petitioners were already evicted, your lordship, on 24. Motion, can it be on 2nd of April, your lordship? Motion, your lordship. What do you have to? Or should we have to? Okay, one day. I will put that. It will be. Motion. Sir, Akan, tell me one thing. How is this order can be complied? Then the public level, and therefore do not have of this matter.
who is to make the payment? ACM. As per verification, the direction to the revenue department. The revenue department direction to give it. There is a direction. Deputy Commissioner has come. So Deputy Commissioner will forward it matter over, but how will you get any benefit on it? Deputy Commissioner has not. Deputy Commissioner has not complied the order here. The last instructions. It's the petition file. Hearing on the ground of willful and deliberate violation to the order is in 3/2025 in the petition number 695 of 2020. The case of the petitioner that was to the direction so fast that the petitioner have not taken any, and as such the instant contempt application. This court has requested with the name, the level government aid to obtain instruction whether the order dated 15/11/2025 passed in so and so have been complied with or not. Copy of the instruction is served upon Mr. Shiraz. So that he may use in the permission to obtain necessary instructions. The name of Mr. Das shall also be shown. It's this matter again. 27th of April 2020. Contact from SQL, party part मतलब best 14 paragraph 6. Get मतलब और extra cost मतलब 16. You are making the DCA party. But after settlement approved by the commissioner and secretary, that has to be issued by the. Just 640. Yes, for the also communicated to the commissioner there. So that's you, no, where is the revenue department? Mr. The application filed for completion of contempt proceeding, it's the response is very for willful and deliberate violation to the order dated 25/7/2023. 878 of the refusal of the order dated 25/7/2025. So that the Commissioner and Secretary of the Government of Assam in the Revenue and Disaster Management Department were directed to take a final decision on the proposal submitted for the receipt to agree. The petition number PRS dot for the date of the it further mentioned further see that on 29/8/2025, the communication, the certified copy of the order dated 25/7/2025 was sent by post to the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department. In the case of the petitioner that the period of 6 months having elapsed and no steps in that regard have been taken, any state application has been filed. This court have requested Mr. Eviction to the Legislative Council of the Revenue and Disaster Management Department to approve instructions as to whether the order dated 25/7/2025 passing the petition number 12 have been complied with or not. A copy of the institution be served to the Legislative Council of the Revenue and Disaster Management Department to obtain instructions in that regard. This court further directs the registry to show the name of the University, the Legislative Council of the Revenue Department in the cosmos. This matter again on 27/8/2025. Outline. The content petition, or it, what is the page 10? Party. Where is the third? Or it was department worship? Huh? Near the worship. When did it happen? Happen worship. Page worship. 18 worship. It is worship. 25/12/2025 worship. Past and.
You served this order on 26/12.
This worship.
Then
One of the petitioner.
you served only on 26/12.
Yes, worship.
Then if it happened on 25/12, they don't know. Why should we initiate contempt proceeding?
And thereafter, worship 8/1/2026. At page 19, worship.
Where is this?
At page 19, worship.
Then
And thereafter, worship 8/3/26, worship. Page 22, worship.
what? The receipt is only on
Worship. Another is worship at page 14, worship. 26/12/2025.
what?
With representation, worship. Along with the order. worship.
26/12/2025, you say that you are approaching the High Court.
No, worship.
Yes.
It is submitted to the representation, worship, the authority. worship.
Kindly see this. That, sir, I have neither so-and-so land, so-and-so, and have also, and I and other persons have submitted the case to the High Court, and the High Court passed the order for taking, for to stop this work.
So solar is allowed to hyper solar is also 3/12/2025.
Notice making it returnable on 11th of May 2026. Steps be taken upon the respondents by way of speed post by tomorrow. The case of the instant application has been filed alleging willful and deliberate violation of the order passed by this court on 3/12/2025 in IS civil number 3925/2025, wherein the learned court made bench of this court, wherein this court passed certain interim directions in the said interlocutory application. The relevant portion of the said order being is reproduced hereunder in given order. Leave of the court. It is the case of the petitioner that if upon receipt of the said order, the case of the petitioner that the said order was served upon the District Commissioner Hailakandi on 26/12/2025, as well as the other respondents. Irrespective of the same, the respondents took steps for carrying out, for disturbing the possession of the petitioner on 8/1/2026, as well as on 5/3/2026. The petitioners therefore allege that there is a willful and deliberate violation to the orders passed by the court. From the materials on record, it prima facie shows that the order dated 3/12/2025 passed in IE civil number 3925/2025 was brought to the attention of the respondents herein, and the respondents thereupon have disturbed the possession of the petitioner. In spite of having knowledge about the order dated 3/12/2025, passed in IE civil number 3925/2025. Under such circumstances, this court have issued notice upon the respondents, asking the respondents to show cause as to why contempt proceedings should not be drawn against the petitioner for willful and deliberate against the respondents for willful and deliberate violation to the order dated 3/12/2025, passed in IE civil number 3925/2025. The said affidavits be filed on behalf of the respondents on or before issue notice কেতিয়া কৰিছো 11th May না on or before 6th of May 2026.
February. Still having to the dedication of the required land. In 2006, but without serving any notice, it is required under 3A to 3G of the National Highway. And thereafter, only in 25, five numbers of representatives, 25. But the respondent is not there. Then ultimately, not there. The land officer was come to an acceptance by 42. This 42 law, it is the letter issued by the additional 50 of land acceptance. It is only 25. Determine the compensation for only the last. And ask the petitioner to produce the bank details. And when I went with the bank details and the other document required by the land acceptance, I was informed that the requiring authority has not deposited the amount of the compensation. And since line 19 years, Lordship, the petitioner is up. Position was taken in.
Now you are aggrieved with what?
Lordship,
You are aggrieved by what?
I have not received any compensation amount till date. And my land was acquired in 2006. Lordship. The compensation has been determined by the land acquisition on 8/25 only.
When was the notice issued under section 3A?
No copy was given.
No, it is a publication of a notice in the Gazette. It is not required to be.
It is very difficult. I tried my best to collect, go through the newspaper. 2006 newspaper. Not available.
Now the question is, have you submitted these documents?
I had gone to submit the document log as per the page 42 letter of the land acquisition.
Then
The land acquisition officer told me that the requiring authority has not deposited.
I am asking you, have you submitted those documents or not? My
No,
question,
we did not accept. I went to submit law. That is stated.
you are saying that a competent authority has not done it, have not accepted these documents after the notice was issued. Is that your case?
Sir, no notices were issued law.
No, notice was issued to you.
Notice was only on 1/8/25 page.
Understood. On 1/8/2025, when a notice was issued asking you to submit the document, is it your case that the competent authority of land acquisition says that I'm not going to accept? Is that your case?
No, that is,
Is that your case?
no. Land acquisition replied that the requiring authority has not deposited the compensation.
I'm not concerned whether they deposit or not, that is not the concern. My question is whether when you went to submit the documents, whether the competent authority have received these documents or not.
No, he did not.
Okay, we issue notice to that effect. Competent authority will be you. Pursuant to the order dated 9/3/2026, you have filed an additional affidavit on 18th of March 2026. You have not mentioned that you have gone to the place and to submit the documents and they did not accept. You only say, see your representation which have been submitted on 9/8/2025, that you are aggrieved with the compensation. If you are aggrieved with the compensation, then you have to go under 3G5. I've looked into it. Are you looking to 9/8/2000 annexure 1 page 49?
So it is not mentioned, but in my affirmative in the affidavit law, I have paragraph 3
Kindly come to paragraph 5 of your affidavit.
that in view of the book situations circumstances and according to the advice of the editor, instead of submitting the document as not by the notified, submitted the.
So you yourself say that you have not submitted the documents.
No, I attempted to submit law.
No, you said that you did not submit on the advice of the additional deputy commissioner, district commissioner, you did not, and instead you submitted this representation. Language is what? I would have understood the language in the representation may not be proper, but the language which is being drafted by the lawyer is not proper.
I file a better.
You need not, you go there and file your PG5. If you agree, and in the meantime, you submit the documents, take the money on the protest. That's all. You will pay the money. Obviously, they would not issue a notice unless the amount has been deposited under 3H1. Isn't it, madam?
Even under section 3, lordship, the position cannot be taken if the amount is not deposited.
Where is it mentioned?
Section 3, lordship position, no notice was issued to me for delivery of the position to the National Highway or the land acquisition.
Mr. Roy, 3D2 categorically says the moment a land notification has been issued, the land automatically vests. It is not required under section similar to section 16, where the possession has to be taken for the purpose of vesting.
No, that is your lordship is correct, but the section, we also provide lordship that a notice will be issued for the, directing the landowner to hand over the position of the land within 60 days. So no notice was given.
Anyway, no notice has been given, you are still in possession.
No. They have taken the position, land, Jamabandi has been corrected, showing it that the land is.
Where is the Jamabandi collection?
Yes, Now I will be invited. Not to be left to come to pay. It will start from page 20.
Where?
What's your page 26 is the translated. I have also filed the vernacular.
Yes.
Page number 26, not to at the bottom. Based on the letter so and so from the additional deputy commissioner and as per the order number. So and so issued by the circle officer. Keeping 1 kata for the charge of the land in party of Kirat Pata number 2 as the original plot is landed from Part B measuring 2 kata 14 letters under the been converted into government land and excluded from the revenue roll of the year. Then next. Please come to page 32. Page 32. Page 32 on the right side, lordship in the middle. Note of the land record, mark lordship. NRL dated 6/7/10 and subsequent order dated 15/7/10 from the number of the number. Part 2. 14 letters designated line number 20 was required for national highway number 30. Required land at government land removed from the statement record. So what to be second Objective section 3H clearly provide that before taking possession, amount is to be deposited. It has been not. Total violation of section 3.
You do one thing, you file your application, submit your document before the authority, the document, they will release. And you file an application before the competent authority, the arbitrator, where is it?
Arbitrator is additional secretary of this two. Revenue Secretary, one Gitanjali.
You file it there.
I'll give you.
And you release the amount upon submission of the documents within 30 days. Release the amount and you in the meantime go and submit them. Because you'll be entitled to everything. Now, if you see the recent judgment of Karsam Singh, uh, it has been delivered, I think, 2-3 days back. Have a look at it.
Yes.
You are entitled to everything. You'll be entitled to not only the compensation, the interest on Solatium as well as on charge. Lower. And if it is, there was no proceedings initiated earlier. I think we do one thing. In the interim, you get the money. You pay the money in the interim upon submission of the document. We keep this matter, taking into account that you have not, as you are now giving the compensation now, you produce what are the 3D notifications you are having, because obviously you have made the assessment now. Then we are not going to look into it. That will be decided by them, but we put the date on which you have to initiate the proceeding, because if you have done at that point of time, you have taken the land and now you are doing it, then the compensation has to be paid as per the 2013 Act.
It will come on the 13th.
13. So
But dear Millard, as per this 182 survey notice, that Kala has given notice. That means the money is lying with the Kala.
maybe,
Like,
but the
it is
fact remains,
if-
no, fact remains that it is the central government who issues those notifications.
For instance, Justice Millard, if we are giving a short date, and this time we be bidding on record, so that it will be. And then
That is why you do it on report.
then after 10 days or after we use that week.
No, I'll have it after Bihu. In the meantime, you paid him the amount once it before the issue notice making it returnable on 4th of May 2026. Mr. Seagull accepts
1, 2,
notice on
3.
behalf of respondent number 1, 2, and 3. He virtually appears on behalf of the respondent numbers 4 and 5. Ms. M. Burman accepts notice on behalf of the respondent number 6, 7, and 8. Extra copies of the petition be served upon the learned counsel representing the respondents by tomorrow. The case of the petitioner hearing is the petitioner is the owner of a plot of land at measuring 2 bighas covered by various darks as detailed out at paragraph number 2 of the petition. In the year 2019, the petitioner came to learn that 1 kata 10 lectures of land from patta number 29 of dark number 126, 2 kata 14 lectures of land from patta number 16 of dark number 127, totaling to 4 kata 4 lectures were acquired by the National Highway Authority of India, was acquired by the central government for widening of the National Highway 1931. It is the case of the petitioner that the requirements of the National Highway Act 1956 of issuance of necessary notifications under section 3A, 3B, as well as 3E, as well as 3G have not been complied with. The petitioner had submitted various representation thereupon. But the competent authority of land acquisition have not taken any steps. It was only on 1/8/2025, a notice was issued to the petitioner that the petitioner should collect the compensation in respect to the acquisition of the land by submitting the necessary documents mentioned therein. It is the case of the petitioner that the compensation which was paid was only a paltry sum without taking into consideration the requirements in terms with section 3G7 of the Act of 1956. The learned counsel appearing on behalf of the petitioner further referring to the judgment of the Supreme Court in the case of so-and-so versus so-and-so reported in 2022, 15 SCC page 1 submitted that the provisions of section 26 to 30 of the Right to Fair Compensation Act 2013 had to be applied while taking into account section 3G7 of the Act of 1956. Which have not been done. And in that regard, the petitioner has also submitted a representation on 9/8/2025, which have not been taken into consideration by the respondent authorities. This court, taking into account the order passed by the learned court in the bench of this court on 9/3/2026, inquired with the learned counsel appearing on behalf of the petitioner as to whether the documents which were sought for by the communication dated 1/8/2025 have been furnished. The learned counsel appearing on behalf of the petitioner, drawing the attention of this court to the additional affidavit filed on 18/3/2026. Submitted that the petitioner is not adverse to submission of the documents. But the said submission of the documents should not be implied that the petitioner has accepted the compensation or has agreed to the compensation. Taking into account the above, this court directs the respondents to bring on record their stand by filing the affidavits on or before the next day as to whether there has been due compliance to the provisions of the Act of 1956 insofar as acquiring the lands of the petitioner. This court further, in the meantime, grants the liberty to the petitioner to submit the documents as have been sought for by the notice dated 1/8/2025 before the respondent number 7. The respondent number 7 being the competent authority of land acquisition. Shall, upon satisfaction of the said documents, release the said compensation amount upon due satisfaction. It is further observed that the submission of the said documents by the petitioner shall not be construed as a waiver of the petitioner to seek for further amounts if the petitioner is otherwise entitled as per law. The petitioner would be liberty to accept those payments under protest.
So they also in the TB hospital method.
Lordship heard the matter yesterday also. Item number 7.
Hey, hold on. Itu kali news na order to pass ko ba? Ito the 29, 29/7, 37 notice from the association. We fix it on the same day.
3 meters, 5, 6,
5, 6, 7. Similar.
5, 6, 7, similar.
5, 6, 7.
Much obliged.
We are fixing it on
8, 8, 8, Lordship.
Yeah, please. In this case, my lord, the victim prays for compensation, or the victim compensation. The husband died. Appeal representation, my lord, that is 26.
Notice meeting is returnable on 6th of May 2025, 26. Involvement accept notice on behalf of the respondent number one. The MV accept notice on behalf of the respondent number two. Involvement for respondent number one, 4, 5, and 6. The MV are on behalf of Chaudhary appeals on behalf of the respondent three. The case of the petitioner herein is that the petitioners husband sustained grievous injury due to an attack by the due to an attack by a person on 11/6/2023 at about 6 p.m. near Kutabari Lokti Mandir Pass by the Gurdwara police station. The husband of the petitioner expired. And in that regard, a case was registered being Gurdwara PS case number 43 of the 23 under section 202 of the Indian Penal Code. The petitioner, being aggrieved, the petitioner had submitted a representation to the member secretary of the Assam State Legal Services Authority for grant of compensation in terms with the Assam Victims Compensation Scheme 2012. The same having not been considered, the petitioner had approached this court. The respondents herein, and particularly the respondent numbers 3, 4, and 5, shall place before this court on the next day as to whether any steps have been taken pursuant to the representation submitted by the petitioner on 7/8/2025. Mr. Madunda, what is this case?
The plot of land was donated and mutated in the name of the petitioner's school, the year of 1997. This plot was donated by one Muslim Uddin, who is the father of the secretary of the school. And in the year of 2025, the same person who was the secretary at that time filed a revenue appeal claiming that trying to set aside the mutation order.
Right? Mutation order challenge before the additional district commissioner. What is wrong?
Okay.
What is wrong?
No,
A
Lord,
mutation order challenge before the.
actually, I am not on that. I am not on the, in fact, I am not on the merit of the case. There is a procedural lacuna and the order is passed without restriction. Because the order which was set aside by the revenue officer in the revenue appeal, that order was never put in the challenge by way of filing the revenue appeal. But if this revenue appeal is on page number 23.
Yes.
Then the first title shows that in the matter of the appeal under the section 147 or 148 of the ALRR against the ensuing order passed by the circle officer, Bipurpur Circle, District, Lakhimpur, Assam. Date is important, 1984 and 2002. This order is put under challenge. Worship may come to the page number 30, which is the ensuing order passed by the revenue officer. And it is clearly reflected
That the order passed by Division Circle Officer of Bhukodia, Circle dated 26/8/19 and 97. So, and this order has been set aside. But in the revenue appeal, this order is not put under challenge. And the foundation of the revenue appeal is defective. Why? Because the revenue officer failed to appreciate the fraud and misrepresentation which is committed by the appellant.
Hey, you issue notice.
Yes, Lordship, notice may go and
Take this point there.
notice may go, Lordship, and the status
You
quo.
raise those points there.
Yes.
Very well.
Basically,
If you raise those
yes.
points there,
this is also
what
interesting.
stops you from going to the Assam Board of Revenue?
Lordship,
Assam Board of Revenue.
perhaps, Lordship, I am entitled to approach before this court also, because there is a jurisdictional error.
We obviously love to hear Mr. Abdek Madunda. That doesn't mean that you shall entertain this type of petition when you have an alternative and efficacious remedy before the Board of Revenue. What raise the issue there?
I could approach to the Board of Revenue, Lordship.
Why?
My
This is-
understanding is that there is this order is passed without authority in fact, because the order which is directed to be set aside, it was not put under challenge. There is a jurisdictional errors.
Mr. Counsel, make a better submission, not that submission. Make a submission to the effect that an order of 1997 has been put to challenge in the year 2025. Has the delay been condoned?
No. There is also one
Make that submission. Make
Yes,
that submission.
that I was supposed to come to that, and that I have explained in my petition itself.
You have explained many things in the petition with headings. As if it would not catch the eye of the court. Yes, you must have thought that the judges must have gone old. They may not see unless you put it in bold letters. It is something like that.
That's why tell the page number 8. 8 of my petition that I have taken the issue. The jurisdictional error regarding limitation under section 148 of some land and revenue regulation.
Okay, now what do I say about 151?
151. Or to call for subordinate officer, the board of deputy commissioner, the settlement officer, and the third officer may call for the procedure. Proceedings shall by any officer subordinate to it or to, and pass such order therein as if from the board of a deputy commissioner or a settlement officer, and the survey officer may call for the proceedings held by any officer subordinate to it, and pass such order therein as if for the things fit. This is saying that the higher officer has the authority to modify the order if someone approaches, agreed party approaches. That the order is passed by the additional district commissioner.
So the power under 151 can be exercised.
Yes,
And,
as
the
per
two-
the,
and there are many judgments of the division bench of the court. If this power under 151 can be exercised at any point.
Yes, as per the law, I am not, that law is very candid. and
Second,
clear.
second, my question. If the authority concerned, you have an appellate remedy, you mentioned, with the way important, you have an appellate remedy, you are not, you are invoking the extraordinary. So, I would also have to look into it, as to whether the order is right or wrong. But do you have any document that your name was rightly inserted?
That copy of the Jamabandi is there.
That is the reason why this mutation appeal happened. My question is, do you have a right over the land? Then why should
Document-
I exercise
Yes,
justice?
that I have explained in my petition, Lordship. The person who preferred the revenue appeal, he was the secretary at that time when the land was donated, and he continued to remain secretary until the year of 2007. But during that time, all the relevant documents were under his possession. And when he has filed the appeal, he was in the good relation with the school management also. But
I
suddenly,
don't know, all the land documents are in his name, it is not in your name.
no,
But the fact remains, you had trusted this particular person and put his name out there because you were the secretary of the school at that point of time.
no, under his possession also. Document was in the school's name, but it was under his
Do you have any document in your name?
Yes, on the basis of that document, my name has been mutated.
Where is it?
That document is under his possession, that issue was
Then
raised,
why didn't you ask it?
that issue was raised. And
Raise the issue before the Board of Revenue.
that issue was raised before the revenue officer itself, but the revenue officer never asked him to produce the same document.
The case where we should exercise our extraordinary liberty.
I am not, Lordship, I am, basically my entire petition drafted, taking a note that there is a jurisdictional error and the revenue officer failed to appreciate the misrepresentation and the fraud.
You can take the issue there before the Board of Revenue.
That is why perhaps, Lordship, although there is alternative remedy, perhaps if I am not wrong, Lordship, may exercise the extraordinary remedy in the interest of
Understood,
justice.
I was there. Yes, it was something which is on the face of it. Now, the fact remains that you have been given an opportunity to produce those documents on which your mutation was inserted. You failed to do so.
No opportunity was given to file
It
my
is
written
mentioned in the order
statement.
itself. During the HUD, I have directed the furnisher registered sale deed in respect of so and so. However, they failed to produce any such document. Okay, they did not give you the opportunity. I give you the opportunity. Show me the registered document.
Registered document or gift.
Yes.
It is under the possession of the,
So go there. You can call for that record. You can call from the revenue records. You can call from the register. If you have, you know the number, call it from the register.
that
But why should this court exercise first?
this is one aspect. That is why I am not submitting on that. My submission is that I am praying this honorable court to exercise the jurisdiction under Article 2 to 6 as because the order is passed without jurisdiction as the order which is set aside by the revenue officer. It has not been put under challenge. And in fact,
This is too meager, too small.
and the limitation period is also there.
Limit is 151.
151 lordship is correct. But the officer who exercise the jurisdiction, he must take note that there is a 148.
Understood, but then also here the supervisory jurisdiction. That is, has been held by our division bench long time back.
So also the basic question that which lordship has raised, that so far I have understood, if there is alternative remedy, under that circumstances, whether I can approach to the court with a prayer to exercise the article 26. And I will satisfy the Lord that perhaps if I can remember, there is certain case laws which will help me.
And I am not satisfied. Go there. Nearby, Assam Board of Revenue, very near.
At least lordship, these points may be taken into consideration. under what circumstances, what prevented the revenue officer to exercise the jurisdiction under section 148, the ALR, because it is mandatory. So if
The moment an application is filed under 147 or 148 without,
it is filed under 147 and 148, but there is no explanation of the delay. The authority who is conducting the hearing or adjudicating the process, he must be satisfied. Yes, there was a sufficient cause which
why didn't
prevented.
you raise the issue there? Raise your objection file there.
That is that opportunity was not also not given to file any objection.
What?
Lordship, it was that they asked me to appear, I appeared, they directed me to furnish the documents, I could not, they passed the order. That is why it is one of the main reason that I have stated in my petition itself.
Where is that statement that they didn't give you? To file reply.
Page number 7. Violation of the principle of natural justice.
Mr. Counsel, this is the ground. Where is the statement of fact? There's a difference. Mr. Mazumdar, you are so good, you know, order 650. In a writ petition, you have to state your statement of fact as well as your submissions both. In a claim, you only mention the statement of fact. Now here, you have to have your statement of facts that look here. I sought for an opportunity, it was not here. There was no granting of any opportunity for me to file a writ. Where is that statement? In your statement of fact. If you have come from the Board of Revenue, I would have immediately looked in. But why should I? Taking into account into failure and fine.
Lordship is, I am not contradicting, in fact, I am accepting whatever Lordship is suggesting. But my only submission is that if I am not wrong, if there is a violation of the principle of natural justice, perhaps I have a,
You have a very good case. It's a violation of the principle of fact. But where is your statement that you were not afforded the opportunity? It cannot be a submission. Submission is different from statement of fact. You have to understand it.
Lordship. This statement is not, is a part of the fact, but it is, I have taken it as a ground, that is also true. So under that circumstances, Lordship may give liberty to amend the petition itself by bringing the fact.
You do one thing, you file an additional
Lordship.
specifically. And produce the audition.
Oh, that's statement.
Audition the PC.
Oh, yes, yes,
Read them.
yes,
And them.
Lord-
That will be good then.
Lordship.
Isn't it? Because you see, we have to overcome also. Yes, the PC did not do it, but then also we have to overcome.
Lordship.
So you need to do something more. Like it.
Yes,
I
absolutely.
think you did not draft to somebody else.
No, that I have done. That it may be because of the limitation of my knowledge that I have taken it down.
There's a very good judgment on how things in the should be. A very nice statement. Different between the- Look into the 1987 day. But people- Give it to you. What is it? No. Mr. F.Z. Mazumdar, the learned counsel appearing on behalf of the petitioner, submits that he will file an additional affidavit by bringing, by for thereby exemplifying those, the material facts as the same would be necessary he further submits that the document pertaining to the order sheet before the learned additional deputy commissioner shall also be produced along with the said additional. It's the matter when
After you come from Lakhimpur, so after 3 weeks.
let's have it on 4th of May,
Also.
4th of May for the additional affidavit be filed.
It please your lordship. Lordship. I'm the ward member of ward number 3 of Chandrapur, Boali Park.
What happened, Mr. Doctor, those matters which have fixed? There were a lot of other matters also, same type of case, 15 pay commission. This must his case that the president and the secretary must have done
Without
on its
holding
own
down.
without giving them, or without taking into consideration their constituency or what. That is his case, yes.
There are 2, 3 cases there.
And there are quite matters where you have appeared. I fixed all those just before me leaving. Then my bench changed to bench 4-5.
At this stage, because of the ensuing elections, my lord, all the members of the Panchayat and offices, my lord, they are engaged in the election process, my lord. After election, my lord.
Why do you say so? The petitioner is here. Didn't he a town panchayat
He's an elected member.
Elected
He's an
member.
elected member. The officials, they were
issue notice making it returnable on 18th of May. Mr. Eltotto accepts notice on behalf of the respondent numbers.
I'm for my lord, 1, 2, 5, 6, and 7.
6 and 7.
3 and 4, my colleague is appearing.
So also accepts notice on behalf of the respondent number 3 and 4. Extra copy of the petition be served upon the learned counsel appearing on 127. As regards to respondent number 8 and 9, steps be taken by the petitioner by way of speed post by tomorrow. Extra copy is by tomorrow. The case of the petitioner herein is that the petitioner is a member of
Ward
which
number-
one? Is a member of
Ward
is
number
the
3 of
elected board member from ward the group number 3 of Chandpur,
Chandpur,
Oliapar,
Boali Park, Gao Panchayat.
Oliapar, G-O-L-A-I-A-R, Gao Panchayat. In the grievance of the petitioner, the respondent number 7 and 8, 8 and 9, 7 and 8, 7 and 8, huh?
Yes.
7 and 8,
7.
huh?
Yes.
7 and 8, unilaterally had made certain recommendation for the use of the funds pertaining to the 15 finance mission.
15 flats
However,
for the year.
the petitioner who is an elected member is however, the grievance of the petitioner who is an elected member have not been taken into consideration.
Lordship, for the untied fund, no scheme has been allotted to him. Only one scheme under
And
Right.
resultantly, no scheme have been allotted to the ward wherein the petitioner have been elected.
under untied terms.
The respondents hearing shall bring on record their stand by filing the affidavits. As to whether appropriate funds have been allotted to the petitioner's ward under the untied grant of the 15 pay finance commission. And if not, why?
Yeah, I pray your lordship, if the action played your lordship that has been, if approved annual funds are granted your lordship, then I will remain
See on the next page.
Hello. Obliged.
Yes, what is this?
Also, the land of the petitioner was required. They have to look at section number 8. Then, my lord, a repetition of file case was my lord. But taken up and the court of my lord, the law, people cannot see in section 17 page 9. The relevant portion is in page 92, my lord.
So where is your reference application?
My lord, in section 18, my lord, page 93.
8?
93, my lord. In section 18. This was required to be forwarded before the competency report, my lord. In terms of this order. That
When
not
was it acquired?
my lord.
When was it acquired? When was it acquired? And was acquired when?
Then required, my lord.
Award passed when?
Two hundred 207, my lord. And final 30, my lord. Assessment was made, my lord, on 12/6/12. It's a 5.
When was the award passed? Award must have
lord,
been
my
passed
lord,
prior to 18/8/2012.
16/8/12, my lord. In it's a 7, my
Huh?
lord. 16/8/12, my lord. 16/8/12.
Then
This amount was not paid, my lord. Quite of repeated request, my lord. Then the petition was filed. Because the court of my lord had ordered dated 16/2/24
where is the direction?
with the direction, my lord. The direction was complied with by the petitioner by submitting the necessary application. It has not yet been forwarded to the competent reference court. Therefore,
When did you submit this document? 16/3. When did you submit this document?
along with my lord, the petition
When did you submit this document?
on
The
16
reference application.
63/24, my lord.
Huh?
63/24, my lord.
16/3/2024.
24,
Where's your receipt?
They have not acknowledged, they have indicated that notice will go to you.
Huh?
They have not acknowledged this, my lord. They asked that necessary notice will go to you, go to the petitioner, my lord. They will issue notice, then better you refer to the reference court. Thereafter, my lord, notice was also given.
Because I gave you only 42 days.
Yes, my lord. Within that time frame, my lord, the petition was filed, petition was filed before the DC, my lord.
But there's no receipt because if I remember,
They have-
when you
Well,
submit.
They have not acknowledged.
Mr. Alam, you-
They have
Mr.
not,
Alam,
they have,
let me tell you, when you submit this application, they give you a number.
my lord, that has not been provided, my lord. We can undertake that they will issue notice to us, my lord, then better you refer to the reference court, my lord.
That is, will happen later on. But my question is, when you submit, because I have given you only 42 days.
Yes, my lord.
Acquisition happened sometime in 2012.
12, my lord. This was started in the year
If we
2007, my
go
lord.
by section 18(2), your period of limitation is either 6 months from the date of the award or within 6 weeks if you have participated in them. You approach this court. So therefore, I passed an order that we let us not go into all these things. We pass, giving you an opportunity to do so within 42 days. Now, whether within 42 days you have submitted this document or not,
I have submitted the same, my lord. Thereafter, your lordship, I cannot see in section 19, page 105. Notice was also given, my lord, by the district court, by street court, my lord. In section 19, my lord, page 115.
so you submitted on 16/3.
So 63, this,
Notice making it returnable on 13th of March 2026. Why are you making so many persons a party unnecessarily?
well, they were the parties in the repetition, my lord.
Not necessary.
Earlier repetition.
No, why do we need the additional deputy commissioner? Why need we need the circle officer? Why do we need the PWD national highway? Why?
My lord,
Your simple question is that there should have been a reference made under section 13, 19. Reference is made under 19 with a statement under say 20.
my lord.
Your simple case, and who is going to do it? It is only the collector who has to do it. Why are you making 3, 4, and 5 and 6?
My lord,
Unnecessary.
they have- my lord, they
You
will-
know, this is notice. You issue notice to one, not two. Two also not the. Issue notice to returnable on so and so.
Use the deputy commissioner.
Returnable, yeah, this one. This court is not, however, inclined to issue notice upon the response number 1, 3, 4, and 5. Taking into account that the dispute in the instant proceeding is only limited to the inaction on the part of the respondent number 2 for taking steps as is required under section 19 and 20 of the Land Acquisition Act 1894. It is the case of the petitioner that Mr. H. Sharma accepts notice on behalf of the respondent number 2. 1 and 2 included. 1 and 2 and so and so. It is the case of the petitioner that the land of the petitioner was acquired
In LS number 13/2007, my lord.
13/2007. And an award was passed sometime in the year 2012. Thereupon, on the ground that the compensation so awarded was inadequate, the petitioner filed a petition before this court, which was registered and numbered as
821990.
8219/2019. This court, by the order dated so and so, 16/2024, granted liberty to the petitioner to submit an representation, an application under section 18 within 42 days from the date of the sale order, and with a further direction that if such application is filed, the district commissioner shall, in terms of section 19 of the Land Acquisition Act 1894, make a reference to the court of the district judge Metro, forthwith and not later than 30 days from the date of such application. It is the case of the petitioner that on 16/3/2024, such application was filed, but till date, no steps in that regard have been taken by the district commissioner, Metro. It is under such circumstances the present petition has been filed. The respondent number 2 herein is directed to apprise this court as to why a reference have not been made pursuant to the application submitted by the petitioner, seeking a reference in terms of section 18 of the Land Acquisition Act 1894, and more particularly within the period as permitted by this court by the judgment and order by the order dated 16/2024 and deputation number 8219 of 2019. The same response will be brought on record by filing an affidavit on or before next to the mention. Issue notice making it returnable on 6 weeks. 13 days. Affidavit be filed on or before 6.
What's it?
May I please the motion? Motion, this matter pertains to grant of Solatium of 30% and 12% interest on compensation. My lord, may remember the case Kanduriwala, WBC number 3496. And here, the coordinate terms of this, of this code has passed
an order pending. Who is acquiring the land? It is my lord, NHA. So. For which land? Yes, for construction of National Highway 31. Huh? National Highway 31. When? It was first acquisition was made in 2005. Thereafter, second phase was acquisition in the year of 2011. So for the first phase acquisition, 30% Solatium and 12% interest was paid. But the second phase, that was compensation was paid, but 30% Solatium and 12% interest is yet to be paid. That is, and a similar matter that was listed on 2095. That matter is literally disposed of on the assurance by the respondent that they are going to pay this 30% solution and 12% interest to the petitioners on or before 22nd of May 2026. So similar matter. No matter not similar. Similar situated matter. That case was filed 12 years ago. What do you mean? My lord, in that case, these petitioners were the parties. And? Yes. You were there? Yes. This is different one. No, my lord, in 2012, that case was referred by Bizni Mahokuma, that is organization, Bizni Mahokuma Katigrosto Patada Sartharakya Committee. And these two petitioners were the members of that threshold and was in that petition as a petitioner. How do we know? Yes, my lord. And fine. Did you submit the list of documents, list of members? What's the name of the petitioner here? Deepak Padgiri and Rashmi Roy. Then? In that petition, I have stated in para number 3, my lord. The petitioner number 1 was listed as serial number 295. In that petitionary petition, 512 it is, 5 and petition number 2 was listed as serial number 218. Then what happened? My lord, as per the order of that 23/5/2017, that this honorable court, this honorable high court was pleased to direct to the respondent authorities to pay the 30% Solatium and 12% interest within 3 months. And my lord, individual representation was directed to be submitted before the NHAI. What is the name of the petitioner? Deepak Padgiri. Where is his name? And Rashmi Roy. Where is the name in the advance slip? Their names, my lord, in the RTI reply, that is, I have annexed at page 27. My lord. You have to show that you are a member of that. My lord. Where is your representation? Where is your representation that you have not been paid as per the direction passed by this court? My lord, representations I have not submitted here. Then, why should we exercise 226?
I have categorical statement I have given here that.
So do I look like the DC or the, what you call the NHIDCL any official like? Do you think that this, you can approach this court direct?
We have submitted representations.
Where? First of all, you have to bring that you are a member of that society. Where is that?
I will put it.
You have not. Secondly, that you have submitted representation showing that you are a member of the society and you have not been paid. You have to bring that. Otherwise, I'm not going to issue notice in this. The learned counsel appearing on behalf of a petitioner submits that he would file an additional affidavit before this court showing that he is a member of the Bizni Mahakuma Kutigosto Patadar Arto Rakta Committee. Bizni. And further, that due representation was submitted by the petitioner, which have to the respondent authority, concerned respondent authority. However, no steps have been taken in that regard. When after vacation, list this matter on 15th of May 2026. In the meantime, the additional affidavit be filed.
May I please the lawsuit? Lord, this is, my lord, in fact, the second round of litigation. My lordship is well aware, my lord, that this matter arising out of, my lord, the issue, then the cause of action is arising out of an order passed by the Honorable Apex Court, my lord. Well, the order of the Honorable Apex Court, my lord, which annex, my lord, they would please to find. That's at page, my lord, 202 annex 10.
Yes.
My lord, what has happened, my lord, initially from the month of, my lord, September, they have initiated the exercise for, my lord, clearing the alleged forest land, saying that, my lord, we are the encroachers, so we cannot be allowed to remain there. So, my lord, there is a series of writ petitions filed there, my lord, matter went to the Honorable Division Bench and ultimately before the Apex Court, and this order is at page 202, my lord. Starts from, my lord, page 203. If my lordship allows me, my lord, may I read over the relevant part of the order, my lord?
What does it say?
My lord.
Tell me.
So, my lord, after this order, the direction which has been, my lord, passed in the last paragraph, my lord, by the Apex Court, the authority have issued, my lord, released a so cause notice, which starts at page 222, my lord, annexure 12. Here from, my lord, they have said, as per this order, my lord, you are further informed that, my lord, can skip the first few paragraph. I am drawing my lordship's attention, my lord, now therefore, from the middle, my lord, in pursuance of the mechanism and on behalf of the district level committee for removal of the forest enforcement constituted for the purpose notified by so and so of the environment forest and so, you are being given another opportunity to adduce evidence in support of your claim of authorized occupation in the said notified forest area. You are hereby directed to submit documentary evidence, if any, within 7 days from the date of receipt of this notice to establish that you are legally authorized to occupy the above forest land. You are therefore, you are further informed that the committee shall examine the documents produced by you and determine whether the land in your occupation falls within the said notified forest area that you are legally authorized to occupy the said land. If it is found that it falls outside the notified area, my lord. So these are the issues, my lord. They have given us 7 days time, my lord, to file our written reply. accordingly, my lord, responding to this, so-called notice, my lord, may be pleased to find, my lord, our reply. My lord, we have not annexed the entire petition, but it starts at page 228, my lord, annexure 13. Is a detailed reply, my lord, we have submitted before the authority, category wise that in what manner, my lord, we are entitled to be remain in the said area, my lord. Now, my lord, after this, they have, my lord, issued the impugned speaking order. After, my lord, considering this, our reply, my lord.
What is this page 263 and 264?
My lord, this is the, my lord, 263 is the, my lord, speaking order. After this, our reply, my lord, by way of this is
What is 264?
my lord. Oh, my lord, that been, my lord, wrongly stitched, my lord. Some replies copy have been wrongly stitched here, my lord. Actually, the speaking order, my lord, starts, my lord can take up the last page, my lord, 274 is the, my lord, full copy. Lord, I'm sorry, my lord, this is our clerical error, my lord. From page 264 to 269 is a part of our reply, my lord, not the part of the speaking order, my lord.
Now what is the grievance?
My lord, the grievance is that, my lord, the replies which we have, the points, my lord, which we have raised, my lord, has not been considered by the committee, my lord. Number one. My lord.
What are your points?
My lord, the points, if my lord may be pleased to take up our reply, my lord, I am not taking my lordship's precious time too much, my lord, but the,
No, Mr.
my,
Counsel, first of all, whether it's a reserve.
my lord, it is their contention that this is a reserve forest. It is their contention, my lord. And we say that though it is a reserve forest, my lord, there is a, my lord, categorical survey had been done, my lord, and it has been constituted as a panchayat village also, my lord.
Panchayat village cannot happen. Reserve forest, once it is declared
My lord,
under the Assam Forest Regulation of 1891,
my lord,
the reserve forest, then under such circumstances, they cannot, the Panchayat village or whatever maybe that those are immediate subsequent. The 1891 Act takes over. And if it is a reserve forest, it is a reserve. Matter ends there. Then there, you see section 17, section 21 of the regulation categorically says that there cannot be a creation of.
my lord.
However, the 2006 provides that in respect to scheduled tribes as well as for forest dwellers, some rights are being provided. If you belong to the forest dwellers out there, having within the definition of forest dweller, that is, if your 3 generations are there, you have a case, otherwise you don't. That's the case.
No, my lord, my lord, it is the allegation and the contention of the, my lord, respondent that we are occupying a particular reserve forest area. So therefore, my lord, when the issue was, my lord, before the Honorable Apex Court, my lord, there was a direction that the demarcation of the land is required to be carried out.
No.
My lord,
Question of demarcation is not the question. Here, when there is a reserve forest, there is a notification issue.
exactly, my lord.
In
There
the
is a
notification, it will categorically say the boundaries of the reserve.
My lord,
Now, if your land falls within the boundaries of the reserve forest, you are out unless you come within the exception of the 2006 Act.
my lord,
That
my lord.
is there. There cannot be any other right unless such right is expressly mentioned in the notification under section 17, giving you that in terms with section 13 of the 1891 regulation, you can get it. Otherwise, you have to.
No, my lord, the issue which we have raised, my lord, before the committee is there, and as well as the honorable apex court, my lord, if my lordship just for a moment, my lord, allows me to draw my
No,
lordship.
I'm not on those.
My lord.
The question is, if it is a reserve forest, you have to show that you have a better right. Unless you say that that is not a reserve forest. Forget about the panchayat. Panchayat has no business of the panchayat coming in later. Once it is reserve forest, it is reserve forest. As per the act, and more particularly in view of the Forest Conservation Act 1980, which now has changed the name into a very difficult name, very difficult to. But otherwise, it remains otherwise the same.
My lord,
One what?
other name.
Change the name. Otherwise, it is the forest.
No, my lord, our contention, my lord, is that, my lord, the issue of the panchayat, my lord, which had been, my lord, traveled to the honorable apex court also, my lord.
Understood, but panchayat, the apex court did not decide on that aspect.
No, that, yes, my lord, that issue has not been decided, but what the apex court direction, my lord,
If apex court went into the question that you should be given a hearing of it, and accordingly, there is a affidavit which has been filed by the state before the apex court that we are going to follow this particular procedure.
Well.
In terms of the procedure, they have formulated a committee, and in terms of the committee, they have issued so-called notice to you. Upon the so-called notice, you have submitted your reply. You have not been able to show that you come within the exception of a person who is able to reside in the forest. Now, unless you say that this is not a reserve forest, you are the petitioner, you have to satisfy this court that it is not a reserve forest. As per the notification which was issued, that it was a reserve.
no, my lord, the, what my respectful submission before my lord is that, my lord, is that the issue which has not been decided by the honorable apex court, my lord, it had been relegated and directed that the committee is required to decide the merit of those issues which has been raised before the honorable apex court.
The merit is, you see, so many words, merit which has been actually looked into that you have a right to remain
Exactly.
in possession. If it is a forest, if it is a non-forest land, the revenue will take its course, whatever maybe we are not concerned. But the moment it comes under the reserve forest, then the only right you can have is coming under the 2006 Act. That is what I know. You show me any other law by which, unless there is another exception that in terms of section 17 of the 1891 Act, as per section 13, there can be at the time of declarations, those made, you are getting certain benefits. 21. Section 21 of the 1891 Act. What does it say?
Says, Mother. No right of any description shall be acquired in or over a reserve forest except by succession or under grant or contract in writing made by or with the previous sanction of the state government or some person or on whom such right or the power to create such right was vested when the notification of the section 17.
This is what you have to show. This is the exception which we have.
Well, no, my lord, the Forest Rights Act 2006 is very clear, my lord. That is for the purpose of, my lord, those scheduled tribes. My
No,
lord,
otherwise that one.
my lord.
Otherwise,
My lord, the other forest dwellers are also is entitled, but though for coming into the category of other forest dwellers, my lord, we have to show 75 years minimum, my lord. My lord, admittedly, my lord, even if my case, my lordship is going to dismiss, my lord, we do not belong or we do not fall within the category of, my lord, 75 years.
no,
Admitted.
do you come within the category of those persons which have been mentioned there? Because you see, the main problem.
No right of any description shall be acquired in or over a reserve forest except by succession or under the grant or contract.
So succession means you have a right already.
Already.
So by way of that,
Mine.
next grant.
Grant,
If the state had granted a, yeah.
under grant or.
Now
contract.
the state after 1980 cannot grant.
But my lord, then my lord, the panchayat will come into play. My lord.
About that. panchayat, whatever panchayat may say that is immaterial. My question is, a grant can be made by the state, but that state can only make the grant if it is in compliance with section 2 of the Forest Conservation Act. Forest conservation says that for non-forest purpose, you can use the land only with the central government's permission. So you have to show a grant whereby the state has granted after following the mandate of 2. Otherwise, no. Next.
The sanction of the state government or some persons on whom such right or the power to create such right was vested when the notification under section 17 was published.
So at the time of making the notification under section 17, some rights have been served. Some rights is saved. Just for example, at the time, because the notification when it is initially issued under section 4, proposing that this particular land would be taken up as a forest land, there might be they will be calling for various objections. At that point of time, they may say that, okay, I don't give up this right with respect to this, or these rights will be protected. If they have the right to acquire, if they don't acquire, this particular right remains at that time. Now, therefore, the question is as to whether you come within that aspect also. If it is safe, very well. If it's not safe,
We are being allowed to reside therein from, from so many years ago, from 1980.
you have not been allowed, you have resided there.
We have-
And they have not intruded upon your residing.
That is correct, my lord. They have not disturbed us or, my lord, no process for eviction had ever been, my lord, carried out since, my lord, till the month of, my lord, September 2025. Only, my lord, from the month of 2025.
At that point of time,
My-
Mr. Bhuiyan, you have also to understand that the
My-
law had not developed. The law had developed. Law was there. But the requisite for protection of the forest, you see, earlier, prior to the 1980, the forest was for protection. After 1980, it became forest for conservation.
Yes, Conservation Act coming.
So therefore, earlier lands were being reserved for use of the state. Now it is being conserved by the state, taking into account the directive principles of the state policy. So therefore, you have to show how do you fall within it. Otherwise, no case. We have been given a hearing.
Hearing, my lord, our documents, my lord, and the plea which we have taken, where in our reply, my lord, that has not been considered in a full-fledged manner.
What is the plea? Tell me.
The plea which, my lord, may be pleased to find in our reply, my lord.
What is your plea? Tell me. I don't require the
My lord, the plea which we have taken that the foundational record and now they have said that this fall within a reserve forest area. They till date, my lord, the map or the area or the boundary has not yet been, my lord, it has been exposed to anybody, it is within them. We could not get the access of the same, the official records also. Now, there is a, my lord, direction from the Honorable Apex Court that the area should be, my lord, a joint survey should be carried out. Now, when,
There has been a joint survey carried out with the revenue authorities.
no, my lord.
The Apex Court never said that a joint survey has to be carried out with the person of the concern.
Now, my lord, if my lord may be pleased to peruse the order of the Honorable Apex Court, my lord, which is at page, my lord, the operative part at page 214, my lord. Just for a moment, my lord, I am reading the relevant part only, my lord. Page 214, clause 1. Before that, my lord, just small paragraph, my lord, which is said, thus from perusal of the aforesaid additional affidavit filed on behalf of the respondents, the following policy decision to remove unauthorized occupation from the reserve forest has been taken. The respondents shall constitute a committee comprising forest official and revenue official. This said committee shall issue notice to the alleged unauthorized occupants and shall give them an opportunity to adduce evidence to show that they have the right to occupy the land which is in their possession. The action for removal of enforcement shall be taken only if it is found that there is an enforcement in the reserve forest area. In case the notice is found to be within the revenue limits outside the notified forest area, the detail of the notices shall be sent to the revenue department. In such cases, revenue department shall decide the future course of action. Now, my lord, my respectful submission for this paragraph is that, my lord, whether the land falls within the revenue or within the forest, my lord, that exercise, they were required to be carried out, my lord.
They have carried out.
No, my lord, they have
They
said, but
carried
my
out.
lord, when and where and in what manner they have carried out, my lord.
That is not for them to say, but they have already that upon detailed joint verification by
Fine.
the committee members, it is clearly emerged that the notice is in unauthorized occupation of Lutumai Reserve Forest.
No, that is, my lord, that is written here in the speaking order, my lord. That is written there in the speaking order, but in the ground reality, my lord, we have never came across any officials or somebody came or the verification.
You are going to, do you want that these officials should go deep inside the reserve forest in your presence?
Sounds right.
You may say today one,
Fine.
in this case, we have 8 petitioners. You may say that, okay, petition number 4, 5, and 6 might have seen that, but the other petitioners did not see it.
I'm not on that, my lord, at least.
They say
Fine.
that we have verified.
Fine.
So therefore, your basic question is to, you are the proponent out here. You have come before this court that they have looked into this on all these things you have in your support of your case. You are to therefore show us that this land does not fall, you are in occupation of land which is outside the reserve forest. If it is outside the reserve forest, you have a case.
No, my
If
lord.
you doesn't have, if
My
you,
lord, my
no.
lord, for that, my lord, my submission, my lord, would be, my lord, it is the government is the authority, my lord, who has raised the issue that we are residing within a reserve forest area, my lord.
You are saying, no, the government is saying that you are in reserve forest.
That is-
different. They say that upon verification, you therefore, you are the person who is come before us. It
Well-
is your burden to show that you are not in the.
That is correct, my lord, but the very basic question has been, my lord, evolved from the, my lord, act of the respondents, my lord. They have said that we are occupying in a, my lord, forest land area, but till date, my lord, neither by of an affidavit or any material, my lord, they could demonstrate before my lord that this is the map. My lord, just for, my lord, I know what is my fate, my lord, before my lordship, but my lord, the area or.
The fact remains that while we are also conscious about the rights of the persons concerned,
My lord.
at the same time, it is also a fundamental duty of every citizen under 51A to look into it, that they don't include the reserve forest, which is mentioned to be it's a property which implies in the section Article 49 will come into the picture.
Part 4, my lord, 51.
Part 4 is there. I'm saying what 59 will come into the picture. The state shall in particular direct its policy towards securing the ownership and control of the material resources of the community are so distributed as best to subserve the common good. This is our duty. We cannot keep it to 51. It shall be the duty of every citizen to value and preserve the rich heritage of a country, to protect and improve the natural environment, including forests, lakes, so and so. It is your duty also.
Fine.
The 51.
My lord, that is, my lord, we are also duty bound to, my lord, as per this constitutional mandate to protect the forest. That is correct, my lord. But it is the duty of the state also, my lord, that being a welfare state. Now, my lord, my lordship is well aware, my lord, that many of the people has already been evicted, thrown out. My lord, but till date, there is no rehabilitation scheme. Has been
That is
imposed.
another.
My lord, my lord,
That is another.
My lord. My lord. My lord.
You are evicted, state being a welfare. I've taken up another matter of that issue.
Asylable matters.
But I think the issue on this aspect, that if you want to evict, but then also we are citizens of India being the welfare state, it could be. But you cannot do it at the cost of the revenue of the forest. It has to be by Mr. A. Bhattacharya, the revenue. Who has to take into account those aspects. It is their duty now. They are also to look into it. That the people, the citizens of India are protected. They are a welfare. But at the same time, we also need to look into the reserve forests are maintained and is conserved. Word is conserving. The other aspect is different. The word used out there is conserving. Earlier it was protection from others. It's very interesting. In fact, I have noted down in one of my judgments in the division bench matter that you see from 1897 onwards, it was always a protection from others so that the state can use the resources. That is why they were reserved. They reserve it. Okay, we need it for our industry. You see the National Forest Policy of 1961. Thereupon the National Forest Policy of 1987. It gives you an idea to them. But in 1987 as well as in 1980, they changed. Now they're conserved. And this has happened because of the rampant thing which has happened in places like Arunachal Pradesh, Nagaland and all. It led to the PM Godawaran cases. Because there were the rampant rules of the state and thereby the resources were being dwindled.
My lord, in Godawaram's cases also, my lordship knows, there is a direction to constitute a committee statewide to protect and to demarcate the areas, whether these are, but that exercise in our state, has also not yet been done as per my.
That they are doing it because of the fact that if you don't do it, it will have far-reaching consequences.
My lord.
The entire thing will get lost. And it is because of the PN Godavarans and the continuous monitoring. We had some force.
That is correct.
Otherwise, if that matters not, and still remember when the PN Godawaran, I think, was taken up first in the year 1994-95. At that point of time, it was a big hue and cry in the states of Arunachal Pradesh, state of Nagaland. What will happen to the people? Because the entire only where you had the factories, all these factories, and they were only cutting off all trees for them. But later on, things moved.
The state is so conscious, for regarding the clearing the reserve forest, we are not,
But they have taken now from
My lord. My lord.
what their acts of that respect. Yes, you have the rights, but if you are there in reserve forest, you do.
But my lord, that is very unfortunate to say, that this exercise is also a selective exercise. That is also thing, which is very heartening, Selective exercise and selective, eviction to a particular community only,
On that, my
My
learned
lord.
friend filed a
My
PIL management suit.
No.
On that same point, my learned friend filed a PIL management suit where the selective targeting.
No, we have to.
It's wrong to make
I
record.
think you see, I think the Supreme Court judgment categorically mentions that you cannot be selective when not found. Because here, see the paragraph number 13 of page 216. In our opinion, the course of action to be adopted by the state government while removing the encroachment for reserve forest contains sufficient procedural safeguard. The process sought to be adopted by the state government for removal of the encroachment conforms to the principles of fairness, reasonableness, and due process. Learned solicitor has assured us that the mechanism evolved by the state shall be complied with objectively and with fairness while taking action for removal of air in the reserve forest. The parties are directed to maintain air. Shall be only look into this. You want to raise that issue, I think better off would be.
No, I am not on that, that all are human beings, and all our citizens should be treated equally, We do not want.
Mr. Priyanka, you quarrel with that position, and in fact, what is being said out there before the Supreme Court that they are going to look at objectively on the basis of that. And the state is doing so.
Well,
Including some community, and whereas the others have been allowed to retire out there. I think the best was for you to go to the Supreme Court. Because they have given an undertaking before the Supreme Court. Yes, sir. So I think that is there, but as of now, while we are picking up this case, unless we show up, that this particular land where you are there is not a reserve.
Milord, may I make a humble prayer, Milord?
Please.
Milord, as we do not have that access of the record, Milord, that access of the record, Milord, may I pray?
We're doing something.
My lord.
We have it on immediately on next Tuesday.
Fine.
Next Tuesday, let us have this matter. In the meantime, let them produce the notification of the
Yes.
hearing.
Along with the map, Milord.
And joint survey reports also.
My,
There are
Yes.
joint survey reports, my lord.
yeah,
We'll,
So you-
get on record.
Let them produce it,
my lord, my lord.
and once they produce it, I think the thing is they, and they just mention in which area by a short. Which area of that particular place. is there.
My lord.
That's all. Once that is given.
We have all the
the,
coordinates.
The problem is, whatever may be, they say that they have made a joint survey required. You can go ahead and, this particular joint survey report which are there, let them take it on the report.
Right.
We'll have it next Tuesday.
Right.
We don't evict them from the.
Well, that order may not be passed, but they
I'm not passing the.
will not be, because till now, election, my lord, nothing will. Election. In fact, two other retreat.
I think this matter. is also taking into account that
My lord.
we need to
My lord.
the delay, if this matter is delayed later on,
Right.
it will have, means it is neither in the interest of the petitioner. Petitioner also have a right to know. where
True,
it is
true.
going.
Well, it's my
At the
experience.
same time, in the reserve forest, Mr. Puya, whatever may be, in the
Right.
wastelands, I have full sympathy, I can give you a,
My lord has given relief of some.
but not in reserve.
My lord.
Very difficult.
It's my experience, my lord, my undertaking, till the next day, they will not be evicted. But there are two other cases, but very.
We
not-
issue a short notice.
Mine, 7th of.
Issue a short notice, because I don't do ask anything without a notice. Issue notice making it returnable on
7th.
7th of April 2026. Mr.
For all,
I mean, the learned editions, the learned. Edition advocate general, etc. Here's on behalf of.
All the response,
All the response,
all the response.
even the.
Sorry, my lord, except my lord, response 3.
Here's on behalf of the respective numbers. 2, 3.
But I'm appearing for 1, 2,
No, I mean, you don't appear for one. One is chief secretary.
yes, my lord.
You don't appear. Me? Anybody else?
I can appear, my lord.
Okay.
1 I'm appearing, my lord. 3 is
One,
revenue, they are standing. 1, 2,
4,
4 to 11, to 13, my lord.
4 to 13. 4 to 13. Mr. A. Bachchaji appears on behalf of the respondent number 2, 3. Or respondent number 3. Extra copy of the petition be served upon the learned counsel appearing on behalf of the petitioner during the course of the day. '89 with petitioners have approached this court, challenging the various speaking orders enclosed as annexure. Annexure 14 poly. Whereby orders have been passed directing the, informing the petitioner that they have encroached upon the Lutumai Reserve Forest, and they were asked to vacate within 15 days from the date of the said order. Upon hearing the learned counsels at length, the issue which boils down to is whether the petitioners are in occupation of lands falling within the Lutumai Reserve Forest. It is the case of the petitioners. And Mr. A. Bhuya fairly submits, the learned counsel fairly submits, that the petitioners do not come within the ambit of the Scheduled Tribes and Other Forest Dwellers Act 2006, as well as the rights of the petitioners are not said in terms with Section 21 of the Assam Forest Regulation, the 1891. It is the only contention that the reserve forest area, that the land under the occupation of the petitioners do not fall within the Lutumai Reserve Forest. Therefore, the issue boils down to as to whether occupation of the petitioners are within the Lutumai Reserve Forest. This court, while perusing the speaking orders, finds it relevant, to take note of that there is a mention of a detailed joint verification by the committee members so constituted by the governor of Assam by the notification dated 17/2/2026. And in terms with the joint verification being carried out by the said committee members, it is mentioned that the petitioners are in unauthorized occupation of the Lutumai Reserve Forest. During the course of the hearing, this court inquired with Mr. P. N. Goswami, the learned additional advocate general, as to when the Lutumai Reserve Forest was notified as a reserve forest. And if so, there has to be a notification in terms with Section 17 of the Assam Forest Regulation 1891. Apart from that, the joint verification report will also throw some light as regards the occupation of the petitioners vis-a-vis the land falling within the reserve forest, Lutumai Reserve Forest. Accordingly, this court directs the respondent state, more particularly the forest department, to place on record by filing an affidavit filing a preliminary affidavit as to whether thereby bringing on record the notification issued under Section 17 of the Assam Land and Assam Forest Regulation 1891. And further, pertaining to Lutumai Reserve Forest, and further, also bringing on record the joint verification report. It has been also, this court also takes notice that the speaking orders categorically mentions, the orders dated 7/3/2026 categorically mentions that the petitioners have been granted 15 days to vacate their occupation. Mr. P. N. Goswami, the learned additional advocate general, submits that till the next day, he undertakes nothing, no steps will be taken. Considering the above, this court is not therefore passing any interim directions. Let's take one. Showing it as part of.
Fine.
Then you can finish here.
Well, the other matters are also there. Issues are slightly different, but the issue is of reserve forest area.
Up to item 20, man.
Item?
Up to item 20, man.
My items are item 30, 15, 17 and 20.
Wait. Item,
Item next.
here, what is item 15, 16?
Milord, item 15 is a Tongia, Milord, Tongia cultivation.
Item number 13, this order was passed, huh?
Yes, sir.
Item number 15 is?
Milord is also, they are claiming that we are encroachers, but we have said that we are Tongia cultivators. We have been settled in the reserve forest area as a Tongia cultivators.
But in which reserve forest?
My lord,
Which reserve forest?
Lotumai reserve forest, same area.
15 same order will
My
pass.
lord, my lord, my lord.
Ali Akal line at the he court he particularly clearly admits that he does not come under nor receive. The learned counsel, however, submitted that the petitioner have been accorded approval
My lord.
for residing within.
Reserve forest area.
So here you are admitting the reserve forest.
Yes, no, my lord, these people who are residing there in,
Are you admitting that this is the reserve forest?
yes. No, my lord, for this petitioner,
No.
They-
As regards 15, are you admitting that it is a reserve forest?
Yes,
Difference between- Earlier you were not admitting.
no, my lord, that is because we are outside the area, my lord. My lord.
Here in 15 and 16, are you
Right.
admitting that you are reserved for it?
Yes, my lord. Because
Because you
we
are reserved for it, but you
we
are
have-
from here.
my lord. Tongia, my lord.
Yeah. She noticed making it so and so, so and so. These are orders, the order is speaking orders when 7-3.
Yes, 7th, same day.
Same day. Notice orders.
These are all document. Both. So and so, or they are sufficiently that Mr. A.R. Pune, the learned counsel appearing on behalf of the petitioners, fairly submits to the petitioners do not come within the ambit of the right to the scheduled caste, scheduled tribes and other forest dwellers. Rights of Forest Dwellers Act 2006. He however submits that the rights of the petitioner have been duly recognized. Mr. Bhuya,
My lord.
have been duly recognized by the
Forest department as a Tongia settlers, my lord.
forest department as only a settlers
Right.
long when,
My lord, since 1970s, my lord.
then also you don't come.
No, my lord, the concept of Tongia, my lord,
Understood, but then also you are not safe.
my lord, under this 1890 Act, my lord.
1988
No, my lord, what has happened,
and the
Tongia,
1891 Act.
Tongia settlers is a concept, my lord. There, the Department of Forest are saying that we have been given 4 acres of land within a reserve forest area to do only the cultivation of Rupsit cultivation, my lord. By virtue of that, we have also, my lord.
Submitted that
Well,
the forest department in the year 1970, in the
my lord.
1970s had permitted the petitioners to reside therein as Tongia cultivators. We have permitted the petitioners to reside within the Lutumai Reserve Forest as Tongia cultivators. And on the basis of that, they have been residing within the reserve forest. Here, Mr. Goswami, here you file an affidavit in that regard, not for the other one, because here they don't. The respondents hearings, no particularly the forest department shall file an affidavit as to the existence of the rights of the Tongia settlers as claimed by the petitioner. And whether such rights, conferment of rights is permissible in terms with the Forest Conservation Act 1980, as well as the Indian Forest Act 1927. He did not bring them back on, huh? Yeah, but is it 15 and 16 is
No,
Tongia? na?
item number 16 is same as item 13.
Okay.
One. And 17 is same
Same with
15.
13.
as 15 million.
Tongia is 15, 17 and 18.
18.
18 also and 14
14 is also Tongia.
Tongia.
Tongia. Well.
And who is appearing for 14? Tongia.
14 and 18.
Tongia.
Yes. In 18.
14.
14 is similar to 30.
14 is similar to 13.
Okay. 14 will be identical to 13. Well.
14, 13 all over the something to my reason for us. It was one equivalent like 14, right? 14 and 18. 14 and which one?
18.
Now 14 and 16 is same to 13, na?
Yes.
My lord.
14 and 16 are two, that's right, issue notice, returnable area of expert. Tag this language, petition along with it. 15 of applicable, he can make Tongia. I take from notice issue to 17 so and so and take these two petition with 15. 15, na?
Yes. Only thing, my lord.
17 and 18 is
Tongia.
Tongia.
17, 18 is with the 15, na?
My lord. 17, 18 is also Tongia.
It's identical to 15.
Therefore, we can't take. Okay, then done.
Then-
All 18 till 18 done.
Jana
Only
par-
line to the
Item 20 is there, my lord.
and 2020, Mr. Bhunya,
My lord, 20 is a different.
you seem to be the, what you call, the main person against eviction.
My lord, these are very marginalized litigants. My lord.
18 will be identical to 13, my lord.
20, 30.
20 will be 30. They're
20
basically
is for
apprehending
notice.
eviction.
Eviction, my lord, it is not yet any speaking order has yet been issued. My lord, they can follow this apex court direction, my lord, and my lord will comply with the same, my lord.
Which
That
20?
20, my lord.
Speaking order?
Not yet.
Not yet issued.
Then I think we should drop.
Fine.
We close it with liberty to come after speaking order.
Yes, ma'am.
No, my lord, they are what they are doing. They are without any notice. We are apprehending eviction that only our houses may
They
be
have not
demolished.
issued notice.
No, my lord.
We will
still
issue
no.
notice.
My lord.
If we have to evict them,
Then
we have to issue
as
notice.
no notice has been issued,
No,
then we close it on the basis of his undertaking that they will follow as per the direction of.
yes.
Heard Mr. A.R. Bhuya, 20, heard Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petition. Mr. P.N. Goswami, the learned additional advocate general, who appears on behalf of the respondents. Mr. So appears on behalf of the revenue department, and Mr. B.K. Videta appears for the respondent number 1, Union of India. The petitioners herein have approached this court, apprehending that without any notice, the petitioners would be evicted from their occupation. Occupation. You are Tongia.
No, my lord. No, my lord.
When 20 is not Tongia, na?
20 is not Tongia.
Occupation, which the respondent authorities claim to be a part of the Lutumai Reserve Forest. Mr. P.N. Goswami, the learned additional advocate general, submits that taking into account the directions passed by the Supreme Court in dated so and so in Abdul Khalek versus so and so, reported in so and so. I think it's reported in SEC online.
Yeah.
Fine. I said about this. The forest department would not evict the petitioners without following the directions passed by the Supreme Court, isn't it?
Yes.
Taking
We'll comply
into
with the
account-
direction. We'll comply with the direction.
without complying with the directions of the Supreme Court in the said order. Taking into account the above, the apprehension on which the petitioners have approached this court seems to be unfounded. And accordingly, the instant with petition therefore stands closed. Be that as it may, it is observed that the forest department and it is observed that in the circumstance the forest department wants to initiate any process of eviction of the petitioners herein, the mandate, the judgment, the stipulations contained in the judgment of the Supreme Court in the case of Abdul Khalek Sutta shall be duly observed.
Only thing, my lord, item 16, my lord. My lord, it's
16 goes up.
16, my lord, 16. Reserve forest is, my lord, Borpani reserve forest, not no document.
It will go up.
Borpani, Borpani, Borpani reserve forest.
So there we need to pass, it is similar, Tongia, no.
No, 13, my lord, it's similar to
It
13.
is 13, but here you have to find that category.
Yes.
It's the same order, no? The ballpark.
Instead of Vituma, it will be Borpani.
It's the 13 or stuff, maybe the whole order. I will keep it on the kind of connect for.
What on the submit? I have one submit. So basically, while they have issued the speaking order, my lord, my representation was not considered. That is also a.
That he has been making the submission, I'm looking. What is considered? No, I therefore say, what is your source? Only thing out there is, first, it's Tongia.
No,
Whether-
in item 14, it's regard, my contention is that we are within the revenue limits. My lord.
Understood. So that is Lutuma.
Yes, no,
He will show that map, no?
yes.
So that is therefore it takes care of that. So I say that it boils down to the issue as to whether it is the reserve forest or not. So they have asked them to produce that notification.
And we have annexed, some revenue receipts also here.
In this case, my lord,
Revenue receipt, revenue may do whatever may be. It has to be, if it is in terms with that notification. If it is the notification is there, your revenue receipts, revenue doing anything, revenue has no business. You see section.
section 4, my lord.
Huh?
Regulation 4, my lord.
No.
Reserve forest is excluded.
Yeah, section 5 of the Assam Land and Revenue Regulation 18. It cannot, the revenue has no business in respect to forest lands.
Chapter 2 regulation.
But my lord, government has
Therefore,
taken
lands
the revenue.
exempted, it's land included in any forest constituted a reserve forest under law for the time being in force is exempted. So therefore, the revenue has no business. And if they too ask the money from.
Government has accepted it, that revenue.
Ask the money from.
Yes, definitely.
Well,
Return the money.
his contention is that his representation has not been considered. And I have written instruction that the representation that he has annexed with a seal, that seal is false.
Oh, in the,
Receipt seal that we have received he is saying that despite receiving the representation, we have not taken any, not considered the representation.
You put it on the.
Yes, I'll put it on affidavit because they have fought, my lord,
in that regard, my lord,
that seal is
I
false.
have that instruction,
fabricated.
my lord, that was genuine, my lord, and it was not forged. So I got that. Info.
Okay, anything else? Now come to 19. Which 19?
Much of it.
What is this?
My account has been frozen without any notice.
What?
My bank account has been frozen without any notice, Your Lordship. I have visited the bank branch. However, I have been intimated that there is some alleged cyber complaint which has been made. And because of that, my account has been totally frozen, Your Lordship. I am, but
Which bank?
State Bank. It's been frozen since October 2025, Your Lordship. Communicated.
issue notice making it returnable on 6th of May 2026. They are paying for Mr. So-and-so appears on behalf of respond number 1. Extra copy of the petition be served upon him during the course of the day. As regards the respond number 2, the petitioner is directed to take steps by speed post by tomorrow. Further to that, petitioner granted the liberty to effect service upon the respondent number 2 by way of the state to the registry of this court and file an affidavit of service on or before the next day. The case of the petitioner herein is that the petitioner has a bank account, savings bank account, maintains a savings bank account, bearing number 38843770402 in the Bensamari branch, Nagaon. Of the respondent number 2 bank. In the month of October 2025, the account of the petitioner was frozen on the ground that an amount of approximately 1,000 have been credited to the petitioner's account and being, which is a proceed of a cybercrime. The petitioner on various occasions requested the respondents to carry out, to defreeze the said account by keeping a lien on the said amount of the 1,000. However, no steps in that regard have been taken, and it is under such circumstances the petitioner has approached this court by filing the petition. The respondents herein are directed to bring on record as to why the petitioner's account should be kept frozen. And more so when and whether and further explain and kept frozen, and whether the petitioner can be permitted to use the account, savings account of the petitioner by keeping on lien the amount of rupees 1,000. Please take on. Why this?
I have not determined the compensation of it, how much they are.
Your land has been taken. We'll see. This is done by whom? Huh? This will be done under the Telegraph Act. So you have to follow the law. You must have been, you have not done till now. You are still in possession. Has the transmission line been put over you? Then why you are coming now? You will see when it happens. Why you are here now? Why will the compensation? Compensation will be paid to you. Don't worry. They have to make the assessment as per 16, isn't it? 10 or 16. Where? Work has been done, nothing has been done.
Work started. Where you are.
They are only going to take your right of way.
The tower, not just
So if any land is being taken, they will take it. As of now, whether there is any notification to the effect, then why are you coming now? Huh? They will do. Have they reached your land? Then why should we at all?
Yes, Your Honor.
Huh?
Yes, Your Honor.
Go and submit. You are asking for 2-3 crores per bigha.
Bigger, they have not taken all bigger.
Huh?
They have taken some portion of out of this land.
Has your land been taken?
They have taken.
Where? In exercise of the powers conferred here, the telegraph authority shall do as little damage as possible when it is exercise the power and shall pay full compensation to all persons interested for any damage sustained by them by reason of exercise of such power. We will do it when it is necessary. Why should we do that? And why you are not approaching who has approached, who is doing all these things? Approach the railways. Why have you not approached the railways under whose project it is being done?
We have to approach.
Why are you approaching the district
We have to
commissioner?
approach for number 5 loss. We have to approach the income loss, yes, for number 5.
Where have you approached the response number 5?
We only.
No, I think we are dismissing it. Heard Mr. So-and-so, the learned counsel appearing on behalf of the commissioner. Mr.
For kilos.
Mr. H. Sharma appears on behalf of response number 1, 2,
1, 3 of 1,
4.
1, 2, 4.
And regards so-and-so appears for response number 3. And who appears for icon?
We notice have to go.
Okay, 4. No, not necessary.
Not necessary.
When you are dismissing it, why notice?
Loss.
I'm giving it. The petitioner herein has approached this court, apprehending that the respondent number 5 had who erect a 132 kV transmission line and tower over the land of the petitioner. And no payment of compensation would be made. This court specifically inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner have submitted any representation to the respondent number 5. He submitted. The learned counsel appearing on behalf of the petitioner with all fairness submitted that no such steps in that regard have been taken. Apart from that, this court finds the instant petition to be premature, taking into account that no steps as of now have been taken over the land of the petitioner. In that view of the matter, the instant petition therefore stands closed as premature. However, the petitioner would be at liberty to approach this court in the circumstance no compensation is paid to the petitioner pursuant to any transmission line is erected by the respondents over the land of the petitioner. Yes, within this.
They are land-based persons. So we applied for settlement of that. And they acknowledge our acknowledgement by issuing an acknowledgement. As per notification 11 and 22, they have to dispose of our application in proper. But what happened was that they rejected the application in a very perfunctory manner. They say that we are not in position, we are not found in position. And also, it is stated that the land is already given to somebody else. Well, my humble submission before your lordship, actually this is per person report because land is given to APTCL matter. APTCL beforehand of our rejection of our applications. And I have annexed sufficient land revenue being received. So, my lord, as per land policy, our application is to be disposed of. But they did not do it. And what happened, my lord? 2,558 bighas of land given to APTCL. And we are from possession of, on the possession of the land for 15 years and claiming only 215 bighas of land out of this 2,515 bighas of land. So, my lord, that is a clear discrimination. Another thing is this, my lord. APTCL has been given land. It is shown that this is recommended by the subdivisional level land advisory committee. But thing is this, my lord, they are not in possession. Never they were in possession, but that land has been given, my lord, in violation of section. Section. Section 32 and 41. For supplement of the land matter, there must be some position. Position is necessary. And in that case, my lord, your lordship will see, as per land policy 2019 matter, under clause 1.1 matter, 1.1, that first possession is to be confirmed. And thereafter, my lord, this report will be looked into by the circle officer forwarded to deputy commissioner. And after that, my lord, deputy commissioner recommended, and thereafter, harass maybe what the word will be issued. But it is abruptly done. Nothing has been followed. And your lordship would please give me our rejection order.
Yes,
Yeah,
when
your
was the
lordship.
land
Not
allotted to the? When was the land allotted to the division? Huh? 25. But.
And it's quite clear, man. They have already been evicted.
You have been evicted.
But we are continuing here, my lord, by making some say that our house was there for about 50 years and that was demolished without giving notice, my lord. And thereafter, what happened, my lord? We make some temporary shed and we are living there. Now, your lordship, just I am showing your lordship page 138, my lord. Page 38.
Okay, let us issue notice
My lord.
in this case. Let's see what can be done, because why I am saying so. In terms of clause 14.3, they don't have a right that they would be given the land where they are in occupation. They don't have a right. But there are other parameters which have to be looked into as to whether these people are indigenous, whether they have land or not.
My lord.
Whether these considerations have been taken for allotting some other land. They may not be entitled to the 4 acres, 5 acres, or whatever. There is a difference between giving them agricultural land for agricultural purposes, which the state government may not have so much of land. But they can still give them some other land for their residents of them. So that aspect we look into it. Why the cancellation was only necessary, because If you are cancelling on the ground that that land has been allotted to somebody else, then in that case, you are saying that, okay, we are not exercising our power to give it in the land where you are there. But that doesn't mean that we are not going to consider. But the other parameters are they individual persons? Are they persons who have no land? These are considerations which you have to do.
That instruction I can get. But, but your lordship will consider the para 10 also. At present, they were evicted and they're not in the position of that. And the,
I mean, passing a stay order.
and my lord,
Status commitment, my lord. Every day they are saying that you vacate the land.
You have been evicted. Where is the
That-
question of eviction?
We have been evicted, my lord, illegally. And we
Where
are,
is that somebody?
my lord, we
they
are
will
in
say that
possession.
I
Where
am
we will
still
go, my lord?
alive.
We are landless person.
I don't know. Sorry.
We are landless person, my lord. Where we will go? They should
I
consider.
am not
Your
Mr.
lordship,
Mr. Seth.
your lordship would
Mr.
please
Seth,
to
I
see
can't
case
even
131.
Sorry.
My lord, your lordship
You
would
don't
please, please to see the case 131, my lord. Case 31. 131.
And why do you file one petition for everybody? Everybody has a different cause of action.
No different cause of action, my lord.
They cannot be the same cause of action.
Similar cause of action.
No, it cannot be similar cause of action. Cannot be under any circumstances whatsoever. Applied for land is only reserved for government or public.
Public for land is already reserved for
Public
government
interest
or
always
public
ahead of
purpose.
individual.
Now your lordship will be pleased to see the deal. It is dated 29/7/2025. So it is said that already it is reserved. Now your lordship will see the Jamabandi Kotul matter. Your lordship would be pleased to see this case. Case 208. Approved for city CL on 26/3/2025. APTCL. At that time, our petition was not rejected.
it's recommended.
So it is forward on record now. I humble submission.
Notice making it returnable on 8th of May 2026. It's in public here on behalf of the respondent of one that four,
6.
seven also power.
Where's that?
It's the 20 here on behalf of the respondent of the five. Extra copy of the petition before the contempt on the learned counsel representing the respondent. The case of the petition, 51 petitioners have joined together to approach this court. Being aggrieved by the rejection of their application seeking settlement on the ground that the petitioners are not in possession of the land, as well as on the ground that the land have been allotted to the respondent number 5. Mr. M.A. the learned counsel appearing on behalf of the petitioner have submitted that the petitioner had sought for settlement of around 215 acres of land under their possession. And these applications were filed in the year 2023-24. In the year 2024. However, subsequently, the land have been allotted to the respondent number 5.
Not allotted, matlab, Medipatta issued. Who? Medipatta issued to APDC.
Allotment have happened subsequently.
Allotment is not that directly, Medipatta has been issued.
Once it is allotted, then the Medipatta.
Allotment was not that. PPP matter.
The land have been allotted to the respondent number 5. And thereupon, the patta has also been issued in favor of the respondent number 5. It is the further case for the petitioners that in the meantime, the petitioners have been also evicted. Mr. MEC further, the council further submit that there are various parameters as mentioned in the land policy of 2019, of the Assam land policy of 2019, which stipulates
Was one.
when land can be settled, when wastelands of the state can be settled. And the petitioners herein, who have been residing over the state lands for the last 50 years, have been dispossessed, and their settlements have been cancelled, and their application for settlements have been rejected. The council is hearing on behalf of the respondent state, more particularly the respondent numbers 1 to 4 and 6 and 7 are directed to bring on record the reasons report their stand by filing the affidavits. In the affidavit, the respondents shall also apprise the court as to whether the parameters that the petitioners who are indigenous people of the state of Assam and that they were landless people have been taken into consideration while rejecting their application for settlement. I will challenge the patta.
Yes.
The respondent number 5 would also be at liberty being on record itself by filing them.
But we are landless people, matlab, where will go, matlab?
You don't know, should be evicted is to consider saying, I am not mentioned of the impact with that thing, I have to reject it. I need rejecting it. They may not do anything. They do that is another thing, but as of now, land belongs to.
In order is of 23 mile.
Okay, you make a submission. That now the land belongs to petition.
They are not in possession, matlab. It is only
So they-
paperwork, matlab.
Yes, then, I know you make a submission that the land now becomes, after has been issued to APDC, so they can't exercise powers under 18. Make the submission. Now, APDC's land is between APDCL and you. So they can therefore not exercise 18 to evict you because it is not that land. If it is reserved, it's different. But once the patta has been issued to them, it is they are the owner. For them to vacate you has to be done in accordance with any other provision, not you. Make the submission. Mr. MSC, the learned counsel further submitted that the petitioner, the possession of the petitioner should not be disturbed, taking into account that if taking into account as patta has already been issued in the favor of the respondent number 5, the state under Rule 18 of the settlement rules cannot exercise the power of eviction. Taking into account the above, this court observes that patta issued Patta has been issued. Yes.
They are praying. No, my lord, that is on record.
Patta has been issued. Has the land been allotted to you? Taking into account that the
Patta issued and Jawabandi is
taking into account that the land at present have been allotted to the APDC, to the respondent number 5. This court observed that the exercise of power under section 18, rule 18 of the settlement rules cannot be resorted to by the respondents.
But my lord, there is a contradictory. My lord, para 10 is very much clear. They were not in possession. They were already evicted.
I'm not saying that not to evict. I'm saying you cannot.
No, they were already evicted, my lord. They were not in
I
possession.
am therefore saying that you cannot exercise ruling.
That's a different issue, my lord. But
Mr. Das, you understand, I am only saying that you cannot exercise ruling. They want to hire hooligans, they look
yes,
at
yes,
me.
yes, yes.
But as of now, I'm not. You cannot exercise.
My lord, that a patta has been issued in favor of the.
Huh?
Patta is, no, what I am into, my lord, the para 10, for time being, my lord, only for time. It says they were already been evicted. They were not in possession.
Very well.
But your lordship wrote that it says that, my lord, that the petitioner were in possession of them.
No, he says.
Yes, my lord. That should be it. It is the submission of the.
I'm therefore saying that if the patta has been issued or if any allotment has been made in his name, rule 18 cannot be exercised by him. That is all.
But they were not in possession.
They are not, I'm not asking you not to do, but you cannot exercise it. They may do under a public domain, whatever the thing.
Much over.
Well, Mr. Sheikh, I have given you a good order now. In spite of not making such submission. Huh?
I think against why.
Understood. So now you have to be also considerate to your wife.
But wife already get 15,000, my lord, as interim maintenance. Interim maintenance granted to her for 15,000.
My lord,
And other fighting, sir.
as
other
of now,
fighting is
no
for
single penny has been paid, man. As of now, no single penny has been.
No, that is another
My
thing.
lord.
How?
False submission, total false submission. Yes, my lord, that, my lord, maintenance case is, my lord,
Go there,
pending.
go there, but get this amount attached.
Already,
Go there and get the amount attached, wherever may be, but not here. These type of litigations are not.
I am not saying my planet friend is saying, my.
I'm not on that.
That he is
But,
getting
but
15,000
Mr. says, you need to be considerate to your wife.
I will consider, my lord, I may not consider, court will not spare me. Court will not spare me, my lord, already 15,000 has been allotted, granted to her.
As of now, till
If
date,
I am not paying, my lord.
Mr. Sheikh, till date, I have not found a good case for mediation to refer to mediation, except this. Go to mediation, sort it out, and then come back. Listen to me. But I sort it out with your wife. There. Go to mediator, and then come back. Pass the order. I'm in your favor. But the fact remains that whatever may be.
That is
one
another,
needs to
that is
consider.
another aspect of the matter, my lord. Mediation will be done, maintenance will be given or not, that will be decided by family court. But it is my property, my lord, without any legal basis. How that can be interfered with? I have taken advance money for selling my land. She cannot claim like this, my lord. She claims, she has right. She has many rights against me, my lord.
The land belongs to whom?
Well, belong to myself, my lord. That's true.
How? How?
My lord, it is Patta land.
Patta land, how?
Purchase. By purchase, my lord.
When did you purchase?
My lord, purchase deed I have not, my lord, any. But
You
your lordship will
purchased
start
it
with
when?
19.
Huh?
Is 19, my lord. Nur Mohammed Sarkar Patadar, my lord.
Pattada is different. I'm only, how did your name get inside?
Yes, my lord, your lordship will see in the.
By virtue of purchase in the name of Noor Mohammed Sir along with Sheikh Sundi's queue. Who is Sheikh Sundi queue?
By virtue of purchase. Lord, that approval, or otherwise 17 card numbers, figure 15 lesser, by virtue of purchase is mutated in the name of Nur Muhammad. It is my purchase that there is no doubt about it, my lord. If there is any doubt, my lord, revenue authority would have said that there is some dispute regarding your title. That is not said in the interim order. It is said that we cannot do anything. How does circular succeed?
So you are only selling 15 liters.
One bigger, one kata, 5 lessons by virtue of purchase. One kata, 5 lessons
But Mr. Sheikh, you are selling only 15 liters.
by 2 agreement. B and C. Next up, B and A. Schedule A and B and C. B and C. Total land is 1 bigger, 1 kata, 5 lessons. And I am selling, my lord, 15 lessons and thereafter 10 lessons. 25 lessons. 1 kata, 5 lessons. I tell you. Your lordship will see page 16, thereafter page 7. But which is not possible, not proper to place with your lordship. I have constructed my dwelling house in Gauhati. I practice here about 20 years. Now, my lord, my dwelling house, she is living. I left for Bilashipara because due to dispute. And thereafter, what happened, my lord? My car is in her possession. My big bike in her possession. And
Was this the council who was the PP?
my lord,
The Noor Muhammad is the one who was the PP.
no, no, not that, no, not that Nur Muhammad. Nur Muhammad already died, my lord.
That time.
That time, he died. Nur Muhammad, because he was Sheikh Nur Muhammad and he Nur Muhammad Sheikh Sarkar. This is different person. Now, my lord, what happened? I'm to left Gauhati, my lord, giving my residence to her. Because, my lord, there is dispute. My son, now in a younger stage, my lord, son is used against me.
Huh?
Son is used by my wife against me. Sometimes my son says me in the court campus to beat me. That is my position. So I left for Bilashipara to save my life. It is not proper to say before your lordship because it is not relevant. But my house, I constructed house in that is Hatigam. She is living there.
But this is a different land. In
It's
Gauhati.
a different land. Madam. It's different land. House with land is in her possession. My car is in her possession. Even what happened, my lord? My books, law books, my case files are in her possession. She is not giving. I cannot go there. That is why, my lord, I filed a case to issue search warrant. But the court said that at this stage it's not possible. So search warrant is not issued. I am challenging that before your lordship. So why my books, my case files will not be given. I am handicapped like anything. Now, my lord, I am going to sell my land. She raised objection. Supposing maintenance is given, my lord, your lordship will consider. Supposing maintenance is granted by your lordship, that give 15,000. I am practicing in Gauhati. There is disruption in my practice. I want to Bilashipara, that subdivisional level court. How I will run? Entire thing is disrupted. If land cannot be sold, I do not have money. Where from I give the maintenance also? Maintenance I am bound to pay. But where from? Is it proper that
Yes, who is appearing for the respondent state? No, Mr. Das, this type of order. If a person has a right over the land, it may be very good. But otherwise, each person concerned, the board district commissioner have no business to pass. You are to decide application under section 21A as per the mandate of the state, not on the basis of others. Not directing you to pass the order of granting the permission, you can't be granting the permission as per the law, but not on these things. Heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner. Ms.
If they go for the yes, everything can be sorted out.
Is the state going to pay the interest on the amount? Ms. N. Bordler appears on behalf of the respondent number 1. Mr. N. Das appears on behalf of the respondent number 3 and 5. Mr. So-and-so appears for the respondent number 5. The present petition has been filed assailing the order dated 7/1/2026, passed by the respondent number 5, whereby the petitioner's application seeking permission to sell his land have been rejected. The materials on record show that the petitioner is the owner of a plot of land at measuring
on page 16.
1 kata 5 lechas, situated at Pochim Boragao. What is the tag number?
That number is 1724. Page
1
16.
kata 5 lechas covered by tag number 1724 of KP Patta number 35, situated at Revenue Village, Paschim Boragao, under Moza Jalukbari of Gauhati Revenue Circle in the district of Kamrup, Petro, Assam. The petitioner had entered into two agreements for sale. One with one Mustafa Soifur Rahman, and the other with one Mizanur Rahman for sale of the total land of 1 kata 5 lechas. The respondent number 4, who is the wife of the petitioner, had filed an application objecting to the accordingly, the petitioner sought for permission from the district administration in terms with section 21A of the Registration Act 1908, insofar as the same is applicable to the state of Assam. The respondent number 4 had submitted an objection on the ground of the objection filed by the respondent number 4. The co-district commission, the respondent number 5 did not proceed with the granting of the no objection certificate to the petitioner, public sale permission to the petitioner. The petitioner submitted a representation on 12/11/2024. However, the representation was also not considered by the respondent authorities, thereby compelling the petitioner to approach this court by filing a writ petition, which was registered and numbered at 665/2025. The learned court made bench by an order dated 12/2/2025 directed the respondent number 2 and 5 to decide the said representation. In pursuance to the said direction, notices were issued to the petitioner as well as the respondent number 4. Subsequent thereto, by the impugned order dated 7/1/2026, the petitioner's application seeking sale permission oblique the NOC was rejected along with the representation on the ground that though the respondent number 4 has no right, is not a recorded patadar of the land, but there is a dispute between the petitioner as well as the respondent number 4 over the land. This court have perused the said impugned order and have heard the learned counsels appearing on behalf of the parties. From the materials on record, it is seen that the petitioner is the sole owner of the land which the petitioner proposes to transfer. There is no right of the respondent number 4 over the said land. Under such circumstances, the rejection of the petitioner's application for sale permission by the respondent number 5 by the order dated 7/1/2026 cannot be sustained in law. Accordingly, the incident with petition therefore stands disposed of with the following observations and direction. The impugned order dated 7/1/2026 is set aside and quashed. When did you file the application? The application so filed, number 2, the application so filed by the petitioner seeking NOC oblique the sale permission on 13/6/2024 online, hearing Setu Seva Setu reference number AS 2414064A 7427629 and application number but the applications filed by the petitioner for sale of the no objection certificate in respect to the 2 plots of land forming a part of the petitioner's land be considered by the respondent numbers 2 and 5 without on its own merit without being influenced by the objection so filed by the respondent number 4. Done.
We are dealing.
The said applications be considered within a period of 60 days from the date a certified copy of the instant order is served upon the respondent number 5. Have to by the petition. District commissioner and co-district commissioner. You want to serve both. The respondent number 2 and 5. Like I can't help you to agreement, whatever the agreement says. It is not. The agreement, if it is 35, it is 35, because you all these things away. Yes, wouldn't it matter? Tribal bill. Where is there? Council will retain. I have some orders passed for tribal bill. Tribal bill for orders. That day I passed the ARP. I can do that in copy. Is the tribal bill?
Other order passed by coordinate benches, madam. Actually, look at my lord order.
Tribal bill. Tribal order. Tribal bill.
There are 3 other judgments passed by coordinate benches. On power of attorney.
I don't follow. I follow my own.
Board of copy, my lord, I can pick it up after the.
In the meantime, you vacate it. Whatever. We remove the interim order. Meantime, we'll pass the order after we do it. Throw them out.
Got to pick it up tomorrow.
Now. I can order asking, 70%. Long you buy. Who's appearing? Working. PN Gusami is for forest. You should know which council is appearing for whom. He is not appearing for tribal bill. Tribal bill, I think Mr. R. Pujari is appearing in tribal bill. Then we do one thing, we allow this petition. We cannot evict him. And there is no representation from the respondents. We set aside the eviction. Yes, argue.
And in question, my lord, first directly come to the issue. Eviction order.
Next first, E. Call Mr. R. Pujari. Land sold by Sohar Ali to Mr. Mukiud Amar.
Sohar, they are brothers, man. Mukiud and Sohar, they are brothers, man.
He is selling this land to
His brother Mukiud.
This is a tribal belt.
Chapter 10, eviction is, my lord.
Is this a tribal belt land?
We were never aware, my lord. 1980 transaction took place. Since then, we've been,
No. Whether it was declared as a tribal.
that notice, my lord, 161 notice, my lord. That notice is not available. But Dokin Nadi, I have told, my lord, that comes within title. Some portions of.
Your name appears as where?
Serial number 199, my lord, 864. Pachonipara, Dokin Rani, Majibur Rahman, Majibur Rahman, son of Mutiur Rahman, Rana Ali, son of Mutiur Rahman, and Raju Ali, my lord. All three of them sons of Mutiur Rahman, my lord. But the petitioners are Rana and Raju, my lord. Majibur has not filed.
But these are different pattas.
Yes. Yes. It's all part of the same sale deed, my lord. My lord pledged the sale deed, the picture deed. 4 different plots of land were sold, my lord, by the same sale.
One sale deed.
One sale.
Now this land belongs to Sohar Ali.
All the land belonged to Sohar Ali. Sohar Ali transferred it to Mutiur Rahman by way of sale.
How do you know that it was belonged to Sohar Ali?
There's a registered sale deed, my lord. And the sale deed of Sohar Ali is also available, my lord. My lord.
Where? Lily?
This is the eviction order, my lord. Page 58, 4th paragraph, my lord. Contention, my lord, that the order is perverse, my lord. Because it only considers that person residing in that area should only be persons belonging to that class. There is also a provision for.
Mr. Counsel, you understand that why should we go into this now? I understand the delay in this matter would only aid you in delaying that proceeding which is eventually going. That's the reason why you want to delay. There's nothing. Why should we decide this? You have your plea out there, take the plea before the authorities.
Residing in that area since 1980.
So, prove it. Prove it.
Sale deed, my lord.
Okay, prove it. So, no, prove it that you are residing. Prove it.
My lord,
No, prove it. How do you prove it? Where's your electron? Show me your election here that you are there from that time.
I have pleaded.
No, pleading is not there. You prove it now. You want this court to look into it. Prove it.
My humble submission, I
Then we
may
are
be
going
wrong, my lord.
to- You are arguing this matter means you want to go into the very.
I'm not aware what my law will.
My question is, you say that you are there from 1980. This is a tribal belt created in the year 1950. So therefore, if you were there prior to that, means you have been a resident earlier. And if you were a resident of the tribal belt, at the initiation of the tribal belt, you have a right over that. So therefore, my question out here is, show me, what are the documents which will show that you were resident of tribal belt at that point?
After that question, my lord, I would like kindly pick up chapter 3 for 164. Very big. I'll read it out to you. Rights of settlement holders and landholders. 1. A settlement holder other than a landholder shall have no right to land held by him beyond such as are expressed in his settlement deed. Number 2 is important, madam. A landholder shall have right of use and occupancy in the land held by him, subject to restrictions or modifications prescribed in rule.
You are referring to which section?
164, madam. Chapter 10, Assam Land. Land number 2, a landholder shall have a right of use and occupancy in the land held by him, subject to restrictions and modifications prescribed in rule made under this chapter and to the provisions of section 9, provided that no landholder shall transfer his land in a belt or a block A to any person not belonging to a class of people notified under section 16. Admittedly, my lord, we don't belong to that class of people. To any person who is not a permanent resident in the belt of law. So, my lord, bar on transfer is not absolute. A landholder, irrespective of the fact whether he's an original inhabitant, irrespective of the fact whether he belongs to that class or not, if he's a landholder,
What do you say about 164?
to any person not belonging to my lord, is a
164 capital A.
capital, yes. Bar on acquisition by prescription in a belt or block. I'll read it. Notwithstanding anything to the contrary contained in this act or in any law relating to limitation, no person to whom any land is transferred in a belt or block in contravention of the provisions of the chapter shall acquire any right or title in that land by length of possession, whether adverse or not. It speaks about adverse possession, madam. That is admitted there. My contention is, madam,
See, there cannot be a right transfer. That is the first law. Now, if that right may not be transferred, then you may raise the plea of first possession. That I have been residing all these years over this, to therefore, some right is excluded. Now, let us see. So, who say, provided that further that no such as can transfer in land with the person who is a permanent resident in that block or you have to does not belong to a class of person. Except with the previous permission of the deputy commissioner.
Yes.
Now, where is the permission?
that permission is not. My contention is, madam, it's an official act, madam. There has to be a presumption that it was done lawfully and regularly, madam.
Now, where is your land that you were there at this point of time? How do you show that you were a resident of that land at that point of time?
Father bought a piece of land. Has been-
Father proceed, but was he a resident out there? Because the deputy commissioner may not have looked into all these things. Why not? But where is your document to show that you are a resident of that?
Also, madam, that this aspect was looked into by the deputy commissioner.
No, why should we look into
So,
that
madam,
when you are not there?
The rebuttable presumption, it will be a onus lies, the burden lies on the respondents, madam, state, to say that there was not done lawfully, madam.
Hey, it's not like a big deal.
They are Jamabandi, madam, land has been mutated after. Since My-
Normally happen now.
my uncle was there before 80 also, madam. The land was transferred to my father from my own brother who had transferred that CLD. And that Sahel Ali CLD also I can produce, madam.
So, could you for father?
Father's elder brother. Sahir.
Keramat Ali.
Sahir.
No, you say your father was there.
My father is Motiur, my lord. Motiur bought.
No, your grandfather, Keramat. Keramat was there. Who purchased the land? Who purchased the original land? Sahar Ali, how did he come into possession?
Yes, I have those said. I have those. Sahir Ali bought it.
First of all, you show me where is your residence.
So we belong to the Goria community, my lord. We're residing in Jalukbari, my lord. So, well, chapter
একটু
2 does
পিছু
not,
কারো বলতে হবে। একটু পিছু কারো বলতে হবে।
subject to correction, my lord. Chapter 10 does not provide for a situation, my lord, where after transfer to an original landhold or permanent resident, if the descendants stop residing in that area, my lord, that has not been, that situation has not been taken care of. That there is no bar, my lord.
Garden,
My father or my grandfather might have been, what I'm,
so show me something to that effect. You want to go into inside the merits, so let us see.
I'm just, my contention is, my lord, that the 164, there was a valid permission, there's a presumption that it was done lawfully. If
No, there's no presumption out here. I them. Why should there be a presumption? Where, you see, any sale can happen with that particular document, means with a particular permission. Unless you have that permission, where is it there? Is it mentioned in the sale deed that there is a permission? Normally sale deeds mention the permission.
you check.
Where is it?
So the vernacular is also there, the photocopy of the original.
Where is it mentioned that there was a permission taken?
There was a transfer within the tribal belt. There had to be permission, my lord, in
No.
terms of chapter 10.
Mr. Monto, you have taken up these matters today. I've seen these matters all this while. There's no transfer. These permissions were never taken at that point of time from the DC. They have given clear disregard. This tribal belt evolution of these things is now being looked into. Only recently, it has happened sometime around 2015-16. They have started doing all this. Earlier they were not there. And some other matters that their main problem happens in view of the PIL which is there, 78. So there the problem arose because of that right. Orders being passed out there to remove these tribal belts from these men. It is the PIL filed by one from he has caused all the problem to all you people.
But if my instructions are, my lord, that petitioners belonging to the Goria community, my lord, they've been living in that area, my lord, for a very long time. Jalukbari, Dokhin Rani, they are adjacent places. To admit, my lord, if that permission is not there, there is no right. But if that permission is there, my lord, then eviction would be against Article 21. my lord.
These directions to the mountain. Hang on, Dave. Don't show to Mr. Tam. He doesn't know anything. It's okay.
Perhaps,
Then you can build your case there.
yes, yes. I was not aware of this also.
This is what I'm saying. Because giving you this thing, you can come build it up. Because if you ask this court to look into this,
Exactly.
you can wait to do
Exactly.
Well, this is the same order which happened here. This is another order. Have you got that order of 14.5? There is something order to 10/3/2026. This is the order of 10/3/2026 or 16? 10/3/2026. Right here. Yeah. Keep it. No. 10/3/2026. 16. WBD number 145.
Was settled in the
In fact, the division bench earlier had taken into account the earlier matter pertaining to this particular issue about the Korea community. So the specific opinion in that. But then I referred it and let them go out there. Affected and the authorized occupants who have been possessing, not being persons or protected, cannot be stayed or protected from the this is permitted in the amount to be sanctioned into a moral transport.
We admittedly belong to Korea.
Now you have a registered scheme. You therefore I think you develop your case. Look,
That is also true. All four others have been studying since 1923.
Same thing. It is, no, them also I have passed order. Here also in this case, this is the order. The petitioner hearing claimed that they have rights over the land under their possession wherein they have been initially issued annual pattas in the year 1923-28 and thereupon have been issued periodic pattas. Here the right which they are saying is developed prior to 1950. You see, the tribal belt happened in the year 19. So the question is, if the tribal belt happens after 1950, those rights which are there, they are protected. That is why I was asking Mr. Mohanto that from where did Sohar Ali purchase? If Sohar Ali has purchased prior to 1950, because he has sold it, or if it devolved to Sohar Ali from his father Keramat Ali, and he was there, he had the title over there prior to 1950, obviously he will have a better right. But these are questions of facts which needs to be looked into by submitting a representation. So normally which I pass an order is giving you time for 20 days for filing your representation. They will decide giving you a personal hearing. And after that, they will pass an order and then give another 30 days for you to take legal recourse if comes. Therefore, I'm saying not liberty, I give 30 days to you so that you can take appropriate course of action. That is the order which I can pass. And in fact, that is the only order which would be good for you. Because you cannot prove it here that you are a resident in 1950. These are very difficult. Unless you can show from your voter ID and all these things which are there, you can very well show it there. This is item number 39, 40 is what? 40 is item. Heard Mr. T. Mohanto, the learned counsel, appearing on behalf of the petitioners in WPC number 1586 of 2026. You have a look at this. This is again, I think my order would be better because this is an order where petitions have been discussed exactly on the same basis. Just look, all these things are understood. But see the last part, one, two paragraphs.
Because there is different. There can only take a power of attorney and nothing much else. But we have to take instruction. They are only the, they are right on the power of attorney. Otherwise, nothing. Only that given machine.
So my order is But what I see, anyway, when the state is not opposing, there is no problem. You see, this order, eviction notice, it says, whereas whereas it has come to the notice that the individuals belong in non-protected classes, whereas district commissioner was directed to so and so to conduct detailed inquiry. Whereas directed notice for hearing were duly issued and served by district commissioner on so and so. Whereas during the time of hearing, held from so and so to so and so and so and so, the following individual list state appeared along with documents that were not sufficient to prove themselves as protected class under so and so. Mentioning that the following individual lists are ineligible to possess land and tribal belt area on so and so. Whereas so and so directed the undersigned to initiate eviction process against the non-protected class as for so and so. So now, did you pursuant to the notice submit anything? Huh? No, there was some, Mr. Mohanto, kindly see the eviction order, whereas as directed for hearing was duly issued
Yes.
and served to District Commissioner Jalubari
Yes.
by notice number dated so and so, 14 number and so and so. We are concerned with which one?
My lord, 191. Serial number 191.
No.
One.
Place for Commissioner, you also notice stated so and so. Para.
Pachoni Para. We are considered Pachoni Para.
So there was one notice issue
Yes, yes. My lord would see my
and
lord.
then hearing. Did you appear in person in this
Yes.
hearing?
No, my lord, we did not appear, my lord. It was, I'll read out my pleadings, my lord. And what they want us to prove, my lord, the eviction order is perverse. They want us to prove that we are people belonging to that class. We may not belong to that class. The notice says so, my lord. That we
Okay.
cannot prove, my lord.
No, that cannot happen. Yes, they have not filed affidavit also. They are not bothered. Don't worry, we'll take care of it. In fact, this is the entire technique progress. We set aside this. However, this notice shall be treated as a notice to you and will be submitted. This will be only against those petitions.
Yes. Quadi petitioners, 191, my lord. Serial number 190.
Because they have not taken into consideration, because you have not appeared.
No, not
You
a
submitted no representation. No. They have not sought for your reply.
It was stuck on the wall, I've been told.
No. How can it? And notice was issued here. 17-3.
270220.
Hello, we pass the order tomorrow. Taking into account the strict conflicts from not doing.
I am agreeing and I'm agreeing in the case now.
Okay, tell me what we have to say on this.
The lordship comes to this notice, my lord. It can be considered as a dim notice because they have given a very better chance to appear and to show their, my lord,
Where
legal
notice.
this page 58. my lord.
Yes, where?
It says, my lord, where it has come to the notice that individual belonging to non-protected class in physical possession of the land in the revenue village of
You have already decided that these people are belong to them. And you have asked them to vacate within 15 days.
it also
Whereas
says that
district commissioner directed to initiate an eviction process, therefore the following are directed to vacate, remove. Where is your notice?
submit necessary documents for the legality of the position in the travel bed area.
Where? Which paragraph?
1, 2, 3, 4, my lord.
So that is why I am saying, whereas as directed notices have been for hearing were duly issued and served by district commissioner, there is one number of one notice for entire area. This amounts to be an absolute perfunctory course of action. You have reduced the directions passed by the Supreme Court to a nullity. This can't happen. You have to issue individual notices, these people. Even the mandate of Rule 18 says that you have to issue individual notices. Section 165 also says that you have to issue individual notices. It says you are
That's
doing it
true.
in a rampant manner.
That's true. Submission made that my friend, my lord, he says that it clearly shows that to submit the necessary documents in their possession.
Yes.
There are no documents in my possession to show that I belong to protected class. Admittedly,
No,
I'm not- I
it's
do
not-
belong to protected. What is the notice? Notice says you have to prove that you belong to protected class.
No. To
No, my-
submit necessary documents for the legality of possession in the tribal.
My lord, and as
No.
individuals annexures appeared and
No,
documents
no,
submitted.
Mr. Mohta, to submit necessary documents for legality of possession in the tribal bit.
My lord, should also read the fourth paragraph, whereas during the time of hearing so and so, following individuals appeared and the documents submitted thereon were not sufficient to prove themselves as protected class. Documents submitted were not sufficient to prove themselves as protected class as per chapter 10.
Now, understood. That is a different thing. I'm not on that. Yes, but I am on the question here. This fellow who has filed the resolution is that earlier around this page, serial number 36. Not Ali. These are on the basis of power of attorney. Yes, power. But here, this is the performance. We set aside this. On the ground that you have not given them adequate opportunity. So, or you produce the notice. We produce this notice, a copy of this notice, how it was issued.
While setting aside my lord, my submission, let this notice be considered as a dim notice to the petitioners who are in this. So
Mr. Das, are you aware of that?
no,
The moment you make that submission, you are saying that the earlier order passed by the learned coordinate bench is bad, which has went to the Supreme Court and the Supreme Court has upheld it. You're going to say that, make the submission. Huh? Wouldn't that go against you?
Yes, my lord.
For me to say it's okay, but can you submit that? Because you are then countering the judgment in Shan Mahmood. And that has been already upheld by the division bench. Matter went to the Supreme Court dismissed it on this notice. So therefore, I asked you to produce this notice, which have been mentioned out there in the eviction notice. While you are affidavit. When can you file your affidavit? Do it, because now there's a big problem. There is already a division coordinate bench matter went to on this notice. I have to ask them to differentiate you. Yes. And this is not the manner in how you pass them out. There's no sticking order also.
That I at the moment.
When are you going to put this?
This is will take some time. Till tonight it will be election. All are busy in election process. Today also I sought some information. Same answer came back till 9.
You are also on the same notice, no? In both the petitions, the petitioners have been asked to vacate on the basis of an eviction notice dated 27/2/2026. And the names have been mentioned in annexure
Serial number 199.
Annexure A to the said notice. It's court specifically inquired with the learned counsel appearing on behalf of the revenue department as well as the state respondents as to whether personal notices have been issued to the petitioners, asking them to show cause as to why the petitioners should not be evicted. And further to that, whether any personal hearing was carried out. This court also takes note of that in the eviction notice dated 27/2026, which have been assailed in the instant proceeding, there are references to certain notices. It is the opinion of this court that these on record by filing an affidavit by the respondent state. Inasmuch as the perusal of those notices would show that the procedural safeguards have been duly taken note of. Accordingly, this court, the learned counsel appearing on behalf of the state respondents as well as the revenue department submits that some time would be required in that regard after new government or before new.
Last week of April.
At the request, the matter is fixed on 29th of April 2026. The affidavit be filed on or before 27th of April 2026, bringing on record those notices, reference of which have been mentioned in the eviction notice dated 27/2026. Interim orders passed in both the petitions shall continue till the next day.